I'll check with Lisa, Judge. It's 96, so it's not in JIS.
Okay. Hidden Gardens versus Ronald Wilcox, 2404042.
Your Honor, Brianna Kingsley appearing on behalf of the plaintiff.
Good morning, Ms. Kingsley. How are you?
I'm well. How are you?
Good. You're, this is 2404042 LT. I read your motion. Do you want to argue anything else? Be glad to listen.
Did you got my brief that I filed last week as well?
Your brief, I made sure I read it this weekend.
All right. I would reiterate everything that we stated in our motion and request that an order be entered to allow my client to remove and or demolish the mobile home.
Your Honor, this is Mr. Wilcox's case. Patricia Prutnick on behalf of Mr. Wilcox.
Okay. Well, he's already left, right?
Correct. He's gone and he released his interest in the home.
Right, but he didn't have any ownership interest in the home, right?
He never had title, Your Honor.
There was a lease in his name, so.
Do you have anything that you wanted to say, Ms. Prutnick? I don't think there's much. Your client isn't really involved in this.
No, at this point, he's already done what he did under the conditional dismissal. We're not disputing whether or not the plaintiff can get possession of the mobile home. We just disagree with any judgment going against Mr. Wilcox.
Ms. Kingsley, I hate to do this to you, but I'm back to where I was before. I don't think, look, you got a title holder here that is deceased, the Shirley Louise Campbell. I have no idea how much, if any, equity is in there. I have no idea, if any, as to whether or not she had a will. I have no idea if she had a will, who would be the beneficiary. I'm going back to what I told you before. I don't think I can do this. I know I can't do this. You have to go set up a probate estate and probate the case and then let the chips fall where they may. But I cannot, in good conscience, when I've got somebody who's deceased and we don't know whether or not there's been an estate set up, it appears as though there hasn't been. How can I just suddenly turn over the property to Hidden Gardens? That would be horrible.
Well, we're not asking for ownership to be awarded. You're
asking to destroy it. How do I know?
Based on the condition of the home, correct. It's an extremely dilapidated condition. I mean, all of Ms. Campbell's potential next of kin have been served with a copy of the motion. We've attempted to contact all of them, any potential interested parties. They've been served with it. This home is a 1965. It's an old mobile home that's in an extremely unsafe condition. My client's true recourse here would be to put this in front of you under the guise of this case.
I don't think I can do it. I'm sorry. I'm going to deny your motion for the reasons I stated. And in the future, Hidden Gardens, to me, well, this is a little different issue. I'm sorry. I have to deny your motion. You're going to have to set up a probate estate. Sorry. That's it. Thank you. Do you have another case with me?
I have a couple more. I have Woodhaven Place.
Okay, Woodhaven Place versus Jesse Jones, 2501925.
Kingsley for the plaintiff.
All right. Is Ms. Jones here?
I've not had a Jesse Jones check-in this morning.
Okay, so she had told us last time she was applying for funding. Did we submit her? Did we receive her application?
Judge, I'm double checking right now.
Doubtful when they don't show up.
We have not.
All right, Ms. Kingsley, you can go ahead and proceed with the default.
Thank you, Your Honor. In light of the defendant's failure to appear, I would request entry of a default possession-only judgment. Rent to retain is $4,125.41. Late fees of $195. That is 1 at 55 and 2 at 70. Court costs $178.54. Total $4498.95.
Defendant failed to appear. The relief requested will be granted. That is a default judgment of possession in favor of plaintiff and against defendant. The writ date will be June the 26th, and the amount to be paid to save it from the issuance of the writ is $4,498.95. Woodhaven Place versus Jeanette Jordan, 2501926. Is
Free and accuser for the plaintiff.
Is Jeanette Jordan out there? This was the same thing. They told me that they were applying for funding. Do you see a Jeanette Jordan out there,
No,
Jennifer?
Your Honor, I do not, and I'm double checking the funding application, and I do not have one filed.
Okay, you can go ahead and proceed with your default.
Thank you, Your Honor. In light of the defendant's failure to appear, I would request entry of a default possession-only judgment. Rent to retain $7,336.22. There's late fees of $295. That's 3 months at $70, 1 month at $55, 1 month at $30. Court costs $178.54. That's for a total of $7,000. I think I did my math wrong on that one. Sorry, Judge. I have $78.09, but I don't think that's what that adds up to.
No, I think you're right.
Yeah, I think I did. I think my math is off. Okay, let me.
Wait a minute. You got $373.54.
Okay, so rent to retain should be $7,036.22.
Wait a minute. Wait. What did you say?
Rent retain should be $7,036, not $336. $7,036.22.
I see.
Late fees of $295 for a total of for court costs of $178.54 for a total of $7539.76.
$7539.76. Yeah.
Yes.
Okay. Writ date will be June the 16th. And the amount to be paid to save it is $7539.76. And again, that will be by default. Ms.
right, thank you,
Kingsley,
Judge.
I would almost encourage you to appeal that. And you're not going to hurt my feelings. I never said I was always right. But I would not be doing that. I'm referring to the other case if I didn't think I was. Have a great day.
Understood. I'll talk to my client. Thanks, Judge.
Thank you. Tracy Mitchell versus Portia Ford, 2502106. Good morning. Your name
Tracy Mitchell.
and your name?
Portia Ford.
All right. Did you speak to a lawyer, ma'am?
Yes.
All right. You're ready to proceed?
Yes.
And this is for termination of tenancy. Why don't you have to leave?
I'm already gone.
Did you turn over the keys?
No, I was waiting until today.
Do you have the keys with you?
Yes.
Have you taken all your property out?
Yes.
Do you want to hand the keys over to her?
Yes.
Okay, hand the keys over. And then are you going to be satisfied to dismiss this, ma'am? All you sued for was recovering of possession to terminate the tenancy. And she's turning over the keys, so I don't need to give you a judgment. If there's damage, you could always come back and start an action in small claims or the general civil division of the court to recover those.
I also asked for May's rent, Your Honor.
Oh, wait a minute, you do have that. Hang on a second. You got rent, I see that. I mean, it isn't artfully drafted here, but that's okay. You got rent for May 1,500, and then you said 620. What kind of late fees do you give?
Just moving forward, Your Honor, I just, when I initially filed the 30-day notice, March rent had not been paid. And.
How much is owed?
right now it's 1592. That's the rent and the, like, the DTE bill.
And then, do you agree with that, ma'am?
Yeah.
So you have DTE bill of 9222, and you have a filing fee of 130. Did you have a service fee?
Service fee?
Service to
Yes,
process.
For, $33.
All right. So that should come out to 1663, 1725. Should come out to 1725.22. Do you agree? Is that figure correct? I don't want you to just tell me yes. I want to make sure.
It's fine, Your Honor. I just want to move on.
So here's what I'm going to do. I'll prepare. Ma'am, do you have any defense here at all to this?
Well, yes. Well, first of all,
In other words, let me ask it this way. Do you agree that you stayed in the property and that you owe that amount?
the lease is not up until June 15th on the property.
You just handed her the keys.
Right, yesterday was June 15th.
She's suing you for the May rent.
No, when she initially served me that April 16th, I had just, like she stated that March rent was not paid. That's not true. She served me on April 16th, and I had just paid April's rent, April 15th,
So you owe for May,
for May, yes,
and that's $1,500.
yes.
And she's entitled, you have an outstanding DTE bill.
It should be current, yes.
Wait a minute. What do you mean it should be current? It's either outstanding or it's current.
I mean, well, yes, I agree with the.
9222, right?
Yes,
And then she's entitled to her filing service and the rental rate for the month of May, right? You agree with that, right?
not, why the filing fee? Because what I.
She's always entitled to, anybody getting a judgment's entitled to their filing fee and
Even if
all
the case is dismissed?
This is for money damages. She sued you for money damages,
Okay.
okay? So here's what I'm gonna do. I'll just make a note. Possession case dismissed. Defendant turned over keys and is vacated. And that's true, correct?
Yes,
But a money judgment is entered in the amount of $1,725.22. Can you pay that today?
no,
How much can you pay her today?
I don't have anything today.
Well, let's set up a payment plan. When can you pay this? Where do you work at?
The dental office,
What dental office?
Dr. Kennedy
Where's he at?
in Dearborn,
How do you spell that?
Guinbi.
So, look, you don't want this floating around here. You want to pay her. And you need to start to pay her. She can garnish wages now if she wants to. Okay? You don't want that. If you want, you can fill out a motion for installment payments, and I will grant that, and then, in other words, with a reasonable amount. And then she cannot garnish wages. She could still garnish bank accounts, tax returns, and the like. But I'm gonna let this go with this. I'm gonna give you both time to go down, or I'm gonna fill out the judgment. And I'm gonna have you go down and get a copy of the judgment. Make arrangements to pay her, okay? Can you do that?
Yes.
All right. Good enough. Anything else, Ms. Mitchell?
No, thank you.
Have a great day. Good luck. Do I have a detective here on Spites?
Yes, Your Honor, we have a trooper here.
Okay. Brandon Dominique Spites, 25. M712713. Good morning, Mr. Shemke.
Good morning, Your Honor. Mr. Sheffield, can I get my client approaches, be standing to my legal left?
Your name, sir?
Brandon.
And,
Wait.
and Trooper, your name?
Trooper Mark Feeny, sir.
Good morning. Let me just take a look here. It looks like the signing on record was done on the 11th. And I just want to double check one thing. All right. So we have a CCW, felonious assault and felony firearm charge. For purposes of arraignment, how does he wish to proceed?
Let me wait for more reading. My client stands mute.
All right, sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes.
You have the right to a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one going forward, you should fill out a petition for a court-appointed lawyer before you leave. My court officer will give you that. You have the right to a probable cause conference within 14 days. You have the right to a preliminary exam within 7 days thereafter. At the probable cause conference, your lawyer, will discuss this case with the prosecutor. At the preliminary examination, as to each one of these charges, they're felonies, a 5, 4, and 2-year felony respectively. They have to prove by a probable cause standard that the crime was committed and that you were the one who probably committed the crime. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that as to any one count, that count would be dismissed. If they fail to prove that as to all counts, then they would all be dismissed and you would be discharged. Do you understand that?
Yes.
Probable cause conference will be June 24th at 9 a.m. June 24th, 9 a.m. in front of Judge Hessen. Preliminary exam, July 1 at 11:30 in front of Judge Hessen. Bond.
Your Honor, my client is currently 32 years old. He's not on probation or parole. He is gainfully employed. He's accompanied today by his wife and 2 children. He has a strong family support system. I spoke with my client as well as the trooper. It was my understanding that this case was pending. When he found out that on the fruition, the trooper contacted my client, who made immediate arrangements to turn himself in. Judge, I do respectfully requesting a personal bond. Thank you.
Is that true, Trooper?
Yes, sir. I agree with you. He's been very upfront with me and he's been very compliant.
All right. What is your position on bond?
PR bond, sir. He actually beat me here to court this morning.
Will somebody be there at the Taylor Post? I don't think they do it every day to print and photograph him today.
Yes, sir. Someone's there all the 8 to 4, sir.
Okay. All right, sir, I'm going to give you a $25,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed, starting with June the 24th. You're not to have any contact with the victim, Devin Pryor, or prosecution witnesses except through your lawyer. You cannot write, phone, see, text, email, communicate with him or them, or have anybody else do any of those things for you or on your behalf. You're not to possess any firearms. You're not to possess dangerous weapons, and you have to. Did you say something, Lisa, or was that somebody else?
No, you're fine, Your Honor. I might have bumped my button.
Okay. And you have to go over to the Taylor Police Department MSP post, the MSP post, I should say, to be fingerprinted and photoed by 11 a.m. today, okay? By 11 a.m. today, June the 16th. You're going to go down first. You're going to fill out your petition for a court-appointed lawyer. You're going to go down the hall, get your notice, and we're going to also give you a copy of the order for fingerprints, and you go over to Taylor and get, go to MSP Post and get printed and photographed. Do you have any questions for me at all? Okay, anything else, Trooper?
No, sir.
Mr. Shemke?
No, sir.
Thank you, gentlemen.
Thanks, sir.
Have a good day. Tanglewood. Tanglewood versus Brittany Austin White, 2502138.
Judge Prunick, Your Honor, on behalf of Miss Austin White.
And good morning, everybody. Langston, you're up at the top here. Give me just an idea of where we're headed on some of these. I've got Jeremiah Chaudhry.
Right, he's the first guy.
He's the first guy.
Oh, right.
He's right before the second one.
On him, he's the one we had tested. He's still saying he got information from the FBI that he, and you can also, he had the impediment.
Okay, when did he have a stroke?
They said yesterday.
Which is, see, he just turned
All the medical information they,
us to sign effort. Give me 1 week or 2 weeks at the most to try to work something out on that.
okay. But any medical information needs to be sent to us so we can get all that information to the,
I will get you back. No more.
one at a time. All the medical information that you can get us concerning his health. If you can get it to us, then we'll get it to the people who are administering to him in the jail right now, the health people. They need to know. They need to get as much information.
You talk me and I can absolutely nowhere anyone in that.
You can get, well, it's, look, I have a doctorate in jurisprudence, not medicine. You don't either, probably. You get the information to the people who are in charge of taking care of that. Then they're informed, and unless you know otherwise, for sure, you have to trust they're responsible. They're going to be responsible. If something bad happens on their watch, they're responsible. Nobody wants that. I know the medical people that we're dealing with every day here through this court and through the jail or appear and have always exhibited a high state of responsibility. Nobody wants something bad on their watch. Then who's to blame is mentioned. And the medical people here in this county are very sensitive about taking care of the people who they are in charge of. So just get as much information to them so that they can be most informed. So what doctors tell me all the time is they didn't tell me about this. They didn't tell me about this. And I can't read their mind. And we can only, we need as much information so that they can make them informed choice and decisions in medical needs. I've been doing this for 18 and a half years up here. We seldom have medical problems. And when they do, they're dealt with very responsibly. You can shake your head all day long, man. I've been doing this 18 and a half years. That's enough. That's enough. Okay, that's your personal opinion. I've just been doing this for thousands of cases, 2,500 cases each year for 18 and a half years. I don't know what you're talking about is unique. That's not normal. So just get the information to them because I trust them. They have a long record of doing well, but just get the information to them so they can be informed.
Your Honor,
Back to you.
can I explain to her how to get the information to Jim?
Yeah, yes, sir. Thanks. Back to Jeremiah.
You spoke to him as well back there, and
I can only get from him the same thing. If originally he's on Miss Jenny's case, but no, I'm sitting in for Miss Jenny. But he said that he wanted to go ahead and take the time, but now he changed his mind and he wants to do some kind of stuff for the FBI. So he can take
I was gonna sign him up, and then like I said, Judge, Mr. Daniel was giving me.
Let's bring Mr. Chaudhry in, please, Tommy. Thank you.
Right. And after I started signing, he said he had information from the FBI.
We can always give him. What is it, a cap?
No, we had a deal for 18 months, and he said yes. I'm signing paperwork, and he said the FBI is going to do something. So I said, okay. So I mean, you heard about the FBI?
Yes.
I mean, I ain't making it up. I don't think he said the FBI is going to help with some kind of
He wants
task.
to be an informant.
So
I mean, are we starting from scratch or?
I mean, I was right.
No, I'm talking about, he wants to be informed. Is that something he's decided he wants to do, but he's starting from right now to be that, to get information from here?
You'll get it.
This is Mr. Chaudhry?
That's it.
Yeah.
Let me guys back there.
Jeremiah? Hi. Okay. Mr. Langston Adams is your attorney. He's a nice guy. He's a smart guy. And who's on this one for the state? Okay. As you know, this is a motion to revoke probation. You know, you're on probation for a state jail felony, unauthorized use of a motor vehicle. And Mr. Adams stated that there was an agreement that had been reached for 18 months in your probation would be revoked. You would be sentenced to 18 months in the state jail. You would be given credit for all time you have served, whatever that is. You know more than I do about it. We can pull it up, but you know how long you've been serving. And that is something you were going to agree to. Now he said that you want some time to talk to authorities. And that's okay. We don't want to talk about it, the details. But what difference would that make on this case? Maybe if there's a federal matter, that's something else. You know, I was in the U.S. Attorney's Office for 20 years, you know, and we dealt with federal stuff. We didn't deal with the state stuff. We had federal matters, and then these are state matters, and those are two different things. Would that matter that you want to deal with the federal authorities really have an effect on this case?
For the state, Your Honor, it would not. There's restitution owed in this case, so we're pretty firm on what we're offering here. I believe that
nothing prevents you. We can get information to the authority just to come talk to you if that's what you want, and then you can talk to them and tell them whatever you feel like they need to know. But this is apples and that's oranges. They're two different things, and your attorney could be with you too to make sure that you're not doing anything that could get you into harm's way, you know. But this is something else different. So are we going to take care of this today and then get the authorities? We'll get the authorities to go and see you. Is that what you want to do or not?
Yeah, like at the police. Just ready about just made Facebook, but just something that has the API.
Yes, sir.
There's some people I didn't know. It's Bill Nelson. I might every and they were involved in something that I'm not involved in. And
okay, did you discuss that matter with Mr. Adams?
I didn't.
Well, he's confident. He has your confidence, and he's not going to disclose anything unless it's necessary by law.
So
you can feel free to talk to him so that he can give you advice on how to proceed with the federal authorities.
Yeah, I led with the good young elf, and they didn't want me to. I guess they did something.
Yes, sir.
And I never got to live around with them. Okay. He said we drive with the pit pot. This is great notice, and they had what they're doing.
Okay. Well, it's important if you feel like they need to know, and then let them make the decision, of course. But what do you want to do on this case today? You want to move forward with it today?
Move forward.
Oh, okay. All right.
We can.
Then we now call cause number 23CR309, the state of Texas versus Jeremiah Chaudhry. And you were here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke probation, which was filed on April 22nd of 2025? Can we proceed in summary?
Yes, sir.
And Mr. Chaudhry, you are Jeremiah Chaudhry. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Sir.
All right, lower your hand. Let me ask you, what's going on in Galveston County? Are those matters still pending?
Yes.
Yes, they'll pay. Thank you.
Oh,
Because yes, that
okay.
when he completes this, he'll go back to Galveston and sit on those charges.
Okay. All right. In this case, sir, in summary, this states that on May 23rd of 2024, in this court, you were sentenced by me to 2 years in the state jail. That was suspended. You were placed on regular probation for 5 years for the state jail felony of unauthorized use of a motor vehicle. Is that true?
No.
You weren't put on probation for that?
What? I was going to that, and the answer on the ship, and the girl was set at that's the train, the green sheet. And I didn't what? I mean, 2 hours, use the motor vehicle that I'm done.
So hold on.
I mean, I was completely convicted of 2 charges.
So you're stating that I did not sentence you to 2 years in state jail and then place you on regular probation? You're stating that's not true?
Yes, sir. That was true, but I had to that time they got I was just worried.
Okay. But while you were on probation, but that is true though. On May 23rd of last year, you were placed on probation by me for 5 years, correct?
Yes, sir.
Okay. Allegation, what are we doing on? Which allegation?
There's, Your Honor, the first one.
Number 1 states here that you committed the offense of aggravated assault with a deadly weapon in Galveston County, Texas on or about November 23rd, 24. Is that true or untrue?
Untrue.
That's not true.
I think I was just talking about after my daughter was and
Okay.
yeah, it's a cigarette, but
That's all you need to say is untrue. You don't want to say much more.
he paid me what he asked to range and
Okay. Number 3 here states you committed the offense of terroristic threat on or about November 23rd, 2024 in Galveston County, Texas. Is that true? No, that's not true. Okay. So when do you want to have a hearing on this matter? I mean, those are the rest are fees, and I'm really not comfortable revoking people who generally people pay if they can, and if they don't, unless we know they have wealth, that's kind of a waste of our time because it's not proper to revoke people who are indigent for failing to pay. When can we have a hearing on this?
I'm doing next week.
All right.
Well, Your Honor, if we could have at least a couple of weeks, because I'm not sure what the
Where
schedule is
Galveston
going to be for
County
me.
is?
Yes, sir.
All right, in 2 weeks.
Yes,
We'll reset it for 2 weeks. So we're gonna have a hearing. There is no deal anymore. I'm gonna make all the decision on it. Okay?
Okay.
All right. All right. Thank you.
that's
All right, Ms. Felicia Moore, she's ready.
Police Moore. Thank you.
That's we had agreed to a cap of 4 years.
Yeah.
So we'll need a pre-sentence report. Yes.
I need to come see me.
It's only MTRP. She's an MTRP. She's an MTRP.
Oh, she's in.
Yeah.
Well, if do that, but if y'all are ready to move forward on it, I can make my decision. But-
Yeah.
All right. Come on up. Okay, we now call the 18-2975, the state of Texas versus Police Moore. That's you?
Yes.
Present with your attorney, Mr. Adams, and the state's attorney. There's a motion to revoke probation here in this case. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
And this was filed on April 3rd of 2025. Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, okay. In summary, this motion states that on August 27th, 2018, in this court, you were sentenced to 8 years in prison, and that was probated for 10 years for the third-degree felony of operating a motor vehicle while intoxicated. Is that true?
Yes.
All right. One states you failed to report to the Jefferson County Probation Office, and you were required to report by mailing or online for the months of February through December of 2024 and January of 2025, as ordered by the court in your probation order. Is that true?
I have no idea. I was reporting.
Well, what is it? Okay, what is it she's going to be pleading true to, if any of this? I mean, I didn't. We'll have a hearing here in a little while, but I thought she was pleading true to something or two.
You are telling me?
Yes, that I test positive.
Why did she test positive for drugs and then she didn't blow?
I test positive for alcohol.
And it was at the bottom, judges.
Number three states you failed to abstain from the use of any and all intoxicating substances, including alcohol, in that you provided a urine sample on or about December 19th, 2024, and also January 17th, 2025 in Orange County, which showed the presence of alcohol in your system in violation of your probation order. Is that true or untrue?
It's true. When?
Number 6, state you failed to submit to alcohol tests by failing to submit to I'm not sure what this means. Well, was this at the probation office or were these the interlock device?
These are probation.
At the probation office on September 1st, 3rd, 6th, 7th, 10th, 11th, 20th, and 23rd of 2024, October 2nd, 4th, 10th, 11th, 12th, and 18th of 2024, November 2nd, 7th, and 9th of 2024, December 10th, 15th, 20th, 21st, 25th, and 27th of 2024, January 1st, 18th, and 25th of this year, 2025, all as directed by the court in your probation order. Is that true or untrue?
It does on the yeah.
Right, you didn't.
But she said,
Yeah, I missed,
I'm sorry,
she has a portable,
a portable,
breathalyzer.
okay, there's a difference. That's different from an airlock device. It's a portable thing. An airlock device keeps you from starting the car.
yes, sir.
The other item you have to blow in, that doesn't affect the car starting.
Yes, sir.
Which one is it that you didn't? The portable. Okay. So is that allegation true or untrue as it is alleged?
Yes, sir.
Are you pleading true to that as well as true to allegation number 3 that you pleaded true to? Are you pleading true voluntarily, knowingly, intelligently, and because those allegations are true as they are alleged? You understand? By pleading true voluntarily and knowingly to one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation could be now revoked, and you could be sentenced to no less than 2 nor more than 8 years confinement in prison.
Before.
I'm
Just account.
I'm sorry. No, this is, you're jumping ahead.
Okay.
So just follow with me. We got to put this on the record. Because you were sentenced to 8 years in prison, probated for 10 years. Do you understand here, without any kind of an agreement, you are subject to no less than 2 nor more than 8 years confinement in prison for 1 or more violations of probation. Knowing that, do you insist on pleading true today to allegations 3 and 6 of this motion to revoke probation? I find you are pleading true voluntarily, knowingly, intelligently, and upon discussions with your attorney, you understand and appreciate the consequences of pleading true. Now, there's an agreement that I'm looking at here.
Yes.
Where this says you would be pleading true, admitting to violations of probation, and whatever decision the court reaches, it cannot exceed 4 years in prison. So this is looking at really 2 options here. Your probation could be revoked. You could be sentenced to no less than 2 nor more than 4 years confinement in prison. Also, I could continue you on probation as an option. I think those are the only options here.
That's correct, Judge.
Is that your understanding of the agreement that's been reached between you and your attorney and the state? If I follow this agreement, I'm going to follow this agreement. We'll see where it plays out. You have no right of appeal of your case. Do you understand? If whatever decision I make within this agreement, you can't appeal it. Do you understand?
Yes.
Okay, I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence without objection?
No objection.
Admitted. And this re-verifies that if I follow this agreement, which I'm going to do whatever it is, it will be within the boundaries of this agreement you all have reached. You have no right of appeal of your case. All right. And by the way, you have about 1 year credit in time served.
I have a year.
351 days is what she's figured out. If that's, and that's all the computer data. If that's different, let us know.
Yes, sir.
All right. Go ahead, Langston.
Judge, I'm asking that you consider keeping her on probation for various reasons. One reason in particular being is to my understanding and talking with her, she's never been to the penitentiary of jail or life. Like this, you did come in.
Yes, sir.
She's never been to the penitentiary.
So what's the point on that?
Well, no,
everybody goes, the people who go to prison,
right?
They all go to prison sometime for the first time.
Right. But in this particular case, with your administrative hearing that you had, and I think the court had signed this on 3/18/25. One of the things that points out.
Hold on. Look, I'm looking at this 2015 conviction. It states for driving while intoxicated with a child passenger. It says she was sentenced to 2 years in the state jail.
She told me she's no.
And that was revoked, and she was sentenced to 7 months. She was 2 years in the state jail, probated for 5 years. And then that was revoked in 2018, and she was sentenced to 7 months in state jail. That's prison.
Yes, but I was in the county and I just went to state.
But
Oh,
I know you never walked into the prison. You stayed in the county, but you still were convicted and sentenced to 7 months and given credit for time served. But the judgment says you were sentenced to 7 months. That was the sentence.
Okay.
You just never walked into a prison, you did all your time in the county jail.
So Judge, that's what she meant when she told me she never went to the prison. That's what she told me.
Hold on, there's another one here.
Yes, sir. She went to a state PLC.
Yeah, there was a DWI third. In 2018, she was sentenced to 8 years probation in that. That's this case. That's this case.
That's good.
Then you've got a 2010, you were placed on probation for theft, a misdemeanor, 1 year deferred probation. That was revoked and you were sentenced to 30 days in the county jail. And it looks like what happened, you committed another theft and you were sentenced to 30 years in the county jail at the same time. So you had a revocation of probation and a new theft case and you served those together.
Yes.
Then the DWI misdemeanor in 2014, you were sentenced to 90 days in the jail, probated for 1 year. That was ultimately revoked in 2015 and you were sentenced to 90 days in the county jail there.
Yes.
So you've been sentenced to county jail 1, 2, 3 on at least 3 cases of misdemeanors, then convicted of a state jail felony that was revoked and sentenced to 7 months in the state jail. And then we got this DWI third here that occurred after you were 2 years. Yeah, 2 years after you were placed on probation for the state jail. Not quite 2 years, less than 2 years. In fact, it was right before you were finished that 2 year, but you were on 5 years probation in 2016. And in February of 18, you pick up this DWI third. Okay.
So, Your Honor, I'm glad that you would correct that because I just went off of what she told me. But what I was looking at particularly was in the administrative report, and that's on page 2 of 3. And it had in here where she admitted to relapsing on alcohol in 2024 and January 2025, resulting in positive UAs. She reported she felt she was drowning due to stress resulting from the alcohol use. And a good positive thing I said is that when she questioned more and when she acknowledged what she learned from Safe P, she said that Safe P had helped to get her off of PCP and cocaine, which is a positive.
And cyclidine.
Right, I'm not saying that's a positive, but she's not using that, and she's not using her problem. That's been years. Her positive is that her only problem.
That's a serious crime.
Yes, sir.
Right.
And I know I look forward to paper for you. This is the longest I have been clean off
But you're judged by the choices you make.
Yes.
Okay.
Right. And
you can always start making better choices. That's what's so great about things.
And I have to pick up what I have been making better choices.
Been cyclidine. You know, you're lucky to be alive.
Yes, sir.
I mean, really, that's
I have
it causes people to get up on the top of a building and jump, thinking they're flying. I mean, cyclidine is just straight from the devil.
Yes, sir.
No doubt about it. And just the reason I brought that up is as she just said that she's been clean on the PCP for the cocaine for 3 years. The Safe P did help her with that. And I think that was good in the report. That's what I read about the report. And what I'm saying, Judge, is that if you continue on supervision, her main, I guess, demon to use that word, alcohol. And I think that she's going to be willing to continue with her alcohol treatment. In the report, it said that you were swamped in stress and you were swamped in mental problems. Can we tell the report, what were some problems that were driving you to drink the alcohol? What's going on in your posting?
Just everyday life, and I finally decided to put the effort to.
What do you mean everyday life?
I have children. I'm a single mother of 3 children, and I got my last piece of my life together.
Dependents.
Yes, sir.
They rely on you to role model.
Yes, sir.
Which you haven't done.
And I relapsed.
Okay.
But I put forth, and I went about 1 and 2, and then treatment specifically for my patient officer.
Where the children? Who's taking care of them?
Willing to take full responsibility for my children.
You're supposed to be willing to take responsibility before you make choices to commit crimes.
I do.
While you're a parent, while you're on probation. I mean, that's, you can't say, it's hard to say, well, now I'm going to start following the rules now.
Yeah,
because you still had those same responsibilities when you made these bad choices.
And I let my probation officer know when I relapsed. And I told her.
Oh, I know, but your probation officer is not your choice making. You are your choice maker.
Yes, sir, that's true.
And you have to. He didn't pay for the consequences. You did.
Yeah, I do.
And your children did.
So So can you tell the judge, considering, I think you acknowledge the choices that you made
Yes.
and the burden, and you were selfish, and as a burden that's on your mama with how many kids?
3.
3 kids. And how old is your mom?
She's in her 50s.
All right. And does she have any other responsibilities?
Yes, and she's, yeah,
And what's her illness?
she had sleep problems.
Right. So if you continue on supervision, you will be able to take care of your own kids, right?
Yes.
But then more importantly, as far as what got you here today, as Judge said, is your choices. What are we gonna do about the alcohol issues moving forward?
I'm going to continue to go to AA, Orange AA, like I had been doing.
Well,
Tap into with my sponsor, continue with my steps, pick up what I left on.
how far did you advance in AA and with your sponsor and your steps? How far did you advance?
It's a step 2. Actually, with my sponsor, we had a great relationship.
So when all this started to trickle down, with you, with the blowing and with the failure with alcohol, you said stress of everyday life, but you gotta explain more specifically what that stress was.
Yes, with my own mental health, and I have 2 children with mental health issues as well.
And what are their issues?
What's abnormal about any of that? That's what
Yes, sir.
everybody every day's got responsibilities when you're a parent.
And I understand.
To the children and yourself.
Yes, sir.
Well, you're not telling me anything that everybody in America and across the world have to deal with.
Yes, sir.
You're just making excuses for it. But we, over and over and over again, we have called your hand on it, and you continue to relapse to bad choice making.
I'm trying to make excuses for stations.
So really, all you're doing right now is promising, making a statement. That's all you really have. Your choices have been different, which is what counts. But all you're doing is saying, I'm not going to get in trouble. I'm not going to do this again.
I'm changing my life. You can see on paper that I haven't caught any new cases. This is the longest I've been without any new cases.
Let me read to you what you signed here when you were placed on. Let me do you what you were placed when you were placed on probation, like officer, probation officer. All the people on probation.
Yes, sir.
I agree to follow all conditions imposed upon me, and I know that community supervision can be revoked for any violation. Signed your name. You made a promise to me then, which you broke it. Now again.
So the big question I think you need to actually answer, Judge Stevens, is if you made that promise then and it was broken, if he gives you another shot, what assurances that you can give him that the promise won't be broken again? How about that? Follow the logic.
Yes.
His logic is, the judge's logic is that, hey, you made these promises, right?
Yes.
And then you broke these promises, right? And today we're asking for another shot, right? So then the question, I think the obvious question is what assurances that you can give him today that that won't happen again? And you speak in your own words. Talk to him.
Yes, sir. Like I said earlier, that I was going to continue to go to my AA meetings and get back with my sponsor, but only start from square one and continue to be honest with my probation officer and get myself into an inpatient rehabilitation center.
Well, you weren't honest with him.
So,
I mean, continue to be honest with him. You weren't honest with him.
well, when I let them know that I had relapsed after a year,
You made, in 2010, you were placed on probation for theft. You made a promise, a written promise.
yes, sir.
And that was revoked. That promise you broke. It was revoked in 2011. In 2014, you were placed on probation for DWI. You made a promise, a written promise.
Yes.
I will follow all the terms and probation. You failed, and that was revoked from 2015. In the felony DWI, in 2000, the driving while intoxicated with a child passenger, you were placed on probation, made a promise, signed it.
Yes.
In 2016, you broke that promise, and that was revoked and sentenced to 7 months in the state jail. I mean, really, don't you think you've been given more than a fair opportunity to do the right thing and make the right choices? All you have here is another promise. But hey, I placed you on probation in 2018.
Yes.
You made a promise directly to me, and you've admitted you've broken that promise. That's the 4th promise you've made on legal matters where we stuck our neck out and put you on probation.
When I was still on drugs.
Doesn't matter. It doesn't matter. You made promises. You could have changed any moment. Oh.
But I don't have drugs anymore.
Yeah, but it's still abuse. It's alcohol abuse now.
Yes.
It's still intoxication. Or you get in behind a 4,000-pound missile or vehicle, intoxicated, whether it's drugs or alcohol, and you're legal.
And instead of allowing my life to continue to spiral out of control, I went to my probation officer and I told them what was going on with my
Thank God, because it saved other people out there who are in harm's way from your bad choices. Okay. What are you asking for?
Judge, I was asking that you continue here on supervision, but in the event that you don't, since it's a cap of 4 You pointed out that
Yes.
she got the 7 months in the state jail. To clarify, when she said that she actually never went to the PNP, but she did the 7 months in the county. A progressive sanction if you choose not to keep her on supervision. I'm asking that you don't hit her with 4 years, that 2 years would be progressive because you're going from 7 months to 2. And that would be an increase from the last sentence that you got. So if the court does not continue her on supervision, I'm asking for 2 years, and that would be a progressive increase from the 7 months.
All right, say,
I disagree with what the defendant is asking for and what the defense attorney is asking for.
go ahead.
I refer you back to the administrative hearing, and I would point out to you, Judge, that I appreciate Mr. Menard being here, but this is Ms. LeBlanc's case, and she's actually on vacation. She cares enough about this that she sent me an email stating that if this was
Do you have a copy of that for him?
the email she sent me about her conflict and schedule. No, I didn't send that to
You were
him.
about to make, she was going to make a comment on the case, but.
No, I just know that she's genuinely concerned about her caseload, and so
All
I want
probation officers seem to be caring.
I want to highlight three sentences from the administrative hearing. She stated, remaining drug-free and alcohol-free has been a challenge for the defendant throughout this probation. She has been afforded the opportunity of this department's most intensive substance abuse treatment from the beginning of probation to give her the best chance of being successful. Then I'm going to highlight the last sentence. At this point, probation has exhausted all available resources and interventions to assist the defendant and refer her back to the court. In other words, probation can't do anything more. She's gotten the benefit of every program that we can do, and to do what counsel is asking for and reward her for this conduct by giving her the minimum is not what I suggest.
Okay.
I agreed to a cap of 4 years because her exposure was 8. I was cutting that time in half to recognize that we've done everything we could. I think 4 is appropriate, Judge.
Anything you'd like to say? It's your life. Anything?
Yes, sir.
Okay. Anything else?
That I would like to go to an inpatient treatment.
Anything else you can say from the defense?
Then I'm just asking, like I said, the 2 years would be progressive on top of the 7, but if not, she's saying that she's changed her life and that if you gave her one more shot, the promise that she's broken the path, it won't break now.
4 separate times. 4 separate promises. This would be a 5th promise, right? I mean, we walked it through from the probation office. This is on behalf of probation office. The probation office has exhausted its resources. This case,
Yes,
and
yeah, results of
and that further supervision would be futile.
yes.
All right. Anything else? If not, I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 3 and 6 have been proven true by a preponderance of the evidence or greater, as the defendant has pleaded true to those voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of revocation and imprisonment. Your probation here is hereby revoked. And following this agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for the 351 days that you have served in accordance with that. Do you understand what has happened to the?
So what about
You
the
need-
safety time?
You will be given credit. Safety is not something I have information of, but you will be given credit for all time you have served. You need to be more focused. We'll do our job up here. You need to be more focused on following the rules and being a responsible parent.
Yes, sir.
That's all on this. What about Ms. Painter?
That's what
I know. What are we going to do on this? It says defendant is competent now. What are we going to do?
Give me 1 week at the most, or 2 weeks at the most, and I'll try to work on it.
Okay.
And I believe that's the 3 I had today, sir.
Next is Eddie
I'm sorry.
Davis.
You've already on the line. That's, I got us here, Jacob Robertson.
25 CR 362 is Eddie Davis. Let's see.
Thank you. Appreciate you.
Donald versus Ronald Pittaway. 2502023. Who's Donald? Who's Ronald? Come on up here.
They're both down.
Your name, sir?
He's
He's Donald Pitaway Senior, I'm Donald Pitaway Junior.
Well, who's the plaintiff? I can't even tell.
Me, but my father was the homeowner and stuff, and we had a discussion about that last time we were here in court.
Wait a minute. Who filed the claim?
I did.
You can't do that. Didn't I tell you that? Did I not tell you that? Did I not tell you that?
Yeah, you said something about, well, you're not the homeowner.
Well, and so I adjourned it. You gotta get a lawyer to handle this for you, sir.
I did.
It's not for you, it's for him.
I did wind up contacting an attorney. I don't have I can't meet with him until June 30th.
Your name?
Ronald Dewey.
Who owns this home? You own this home? Yes? I can't hear you.
Yes.
And you're Donald Pitaway Senior, right?
Yes.
And where's the property? On Maple Lane?
No, 2067 on Churchill Avenue.
Why is
the Maple Lane is where he lives.
That's not where I live. My address is.
the property that we're talking about here? Is it for Churchill Avenue? Is it for?
Yes. Yes. That's where we live, Churchill Avenue.
Do you live there?
That's my residence, yes. It's on my driver's license. I live there, my property's there. They tried to take it.
Hang on a second.
They locked the doors on me and changed.
Time out. Time out. You're his son? Are you his son?
Yes.
Well, this isn't very fun.
Exactly.
Who else lives at that Churchill address? Do you live there, Don Pitaway Sr.?
Yes, I do.
Do you live there, Don Pitaway Jr.?
Correct.
And so does Ronald?
And he moved his stuff to the Maple Lane address, and he's trying to get away with living at two addresses when I'm trying to evict him. What's basically going to happen?
Hang on. You are not trying to do anything because you're not the plaintiff. What do you mean, what happened? Mr.
My father's 85 years old, sir.
I don't think he's being disrespectful, but I can't just say whatever. I have to have the real party and interest starting the action. That being said, Ronald, come on. What was yesterday again?
June 15th.
Yeah, I know. What else was it?
Father's Day, I was there.
Yeah. Stop. I didn't ask you that. The Father's Day, right?
Yeah, I just stopped and started to fight yesterday.
Stop.
All my brothers were there.
Listen to me. How many dads you got? That's what I want you to answer. How many fathers you got?
One.
Okay. Yesterday was Father's Day. What a sad commentary that an 85-year-old, and how old are you?
He's 84. I'm just being accurate, sir.
All right. How old are you?
853.
My dad. See that guy in the mall?
I know Gerald.
Huh?
Gerald McCown.
Who's my dad?
Yeah.
53 when he died. How old are you?
56.
You guys are carrying on like that in this world that's so short, this silly, ridiculous, and I've got a lot of other words I could call it, but they wouldn't be appropriate. Now, why aren't you just vacating the house without putting people through all this nonsense? I did not finish asking my question. You keep interrupting me. Why aren't you just moving out of the house? You live on Maple Lane? Yes or no? Do you live on Maple Lane, yes or no?
My address of residence is 20679 Churchill Avenue on my driver's license. Certain my property's there, and I have money invested in that house. And they're trying to take it. He is my brother. I got about $30,000. Who else will do that for their father, sir?
Oh.
Not this deadbeat who's got my dad broke.
Hang on. Watch your mouths. Now listen, 85, 48, don't start swearing in here. I'm as serious as a heart attack now. Stop it.
Yes, sir.
Do you have a lease with him?
A red lease, sir?
I'm talking to your dad. What did I tell you last week? I said you can't be his representative here. You're not a, listen, sir, listen to me, please. Just so you don't think I'm being mean or anything. I cannot allow people to engage in the unauthorized practice of law, and that's what you're doing right now. You're not a lawyer, and you can't represent him. Period. I can't go over and set up a medical office and act like a doctor. You're not going to act like a lawyer. Now, I thought I made that clear. Did I not make that clear?
Yes, you made that clear.
Then why are you here doing the same thing? I don't care what the reason. Look, let me just try to help you guys. Maybe you can save a lot of people a lot of time and a lot of money on lawyers that maybe isn't quite necessary. What do you mean you put $30,000 into the house?
I got the receipts. I put a whole back patio.
You put in a back patio?
All brick pavers, 2 fireplaces, a hot tub. I did it for my mother because.
How long ago?
It's like right around the start on COVID, it got delayed.
Is your mother still alive?
No, she passed away.
When?
18.
So you're telling me you put in brick pavers and what else?
2 fireplaces, a hot tub.
Where's this all at?
All on at my desk.
In the back?
Yes, sir. I got pictures and
And you did this 7, 8 years ago?
No, it's a few years ago. I promised my mom I'd take care of it.
Wait a minute. When did you do that? What year?
It started in 2020.
But your mom was already deceased.
I promised her I'd take care of it.
Your mom was already
I
deceased.
promised her I'd take care of it. I made a promise to my mom and I honored my own. When I moved in there for my divorce, I promised her I'd take care of it. A tree fell down, destroyed the pool. They paid to have it. My dad didn't have the money. I did. So I pulled it out and I took care of it. Like I promised.
You did this 5 years ago.
It started off.
Was there any agreement that he was? You told your mom you were going to do this, right?
Yes, I did.
Because you wanted to be a good son to your mother.
Yes, sir.
And you took care of it even after your mother died.
Yes, sir.
Do you have anything in writing that says your mother, stop, don't interrupt me. Do you have anything in writing that says your father, Don Pittaway Sr. here, agreed to pay you? Yes or no?
No.
You have anything in writing from your mother saying she agreed to pay you, even though this happened 2 years after she passed?
Anything
Yes or no?
No.
How are you going to win this? You want to say something? How long you been living there?
Since like 2018 then.
18? How much you been paying in rent?
$50 a week, just like he paid. My other brother paid $0. And everything I put into the house, my dad said would be taken off my rent.
Have you been paying the rent $50 a month or a week?
My dad took like 5.
Sure.
Yes.
Have you been paying your father $50 a week?
Yeah, he just took like $500 on my bank account.
No.
They take more than.
Wait. You have this terrible habit of interrupting me. Have you been paying since 2018 $50 per week?
Yes.
How you been paying that?
Cash.
Check?
Cash.
Did he take 50? Is he been paying you 50 a week? Look. You know what I think?
I have proof.
How do you have proof? Did he sign receipts? How do you have proof? Did he sign receipts saying every week, my son, Ronald Pittaway, paid me $50 to cover his rent for this past week? Do you have proof of that? Do you have receipts like that? I'm asking you a question.
Make sure I don't interrupt you, sir. I got my bank statements right there. My dad took it out of my bank account. From the bank, I got them out there. They'll verify that he took it out.
For 6 years? Hang on.
He's on my bank account.
For 6 years, he's been taking $50 a
He
week?
takes money whenever he wants to.
Have you been taking money out of his account?
Here's what happened. I didn't even know that he was on the account. And then all of a sudden, I found out he hasn't been paying me any rent. He pays the rent. He's paying.
Who's he?
Ronnie doesn't pay nothing.
Who's he? Don Pitaway Jr.? You pointed to this son. Wait, you pointed to this son, right?
Right.
He's been paying rent.
He's been paying, but the other guy right over there has not. And every time I try to collect from him or something, no, I ain't giving nothing. Well, that was like 6 months ago or something. I found out that he has a bank account where I'm at, and my name's on there as runner-up or whatever you want to call it. So I start taking money out of there.
You did?
Just a minute. He found out about it, and so he cut me off of that. I can't go in there and get money out of the bank anymore for my $50 because he's killing me on.
You kind of lost me. Who's on the bank account?
He's the head on the bank account, and I just found out by accident that I was on there. So I said, well, good, then I'm going to start taking my $50 a week.
When did you start doing that?
Oh, what, about a year ago or something like that? Whatever it was, I would just take it, $50, and he found out, and then he just cut me off of everything. But for years, he didn't pay me nothing. When my son here did.
Even if you've been paying, you have nothing here. You have nothing. He has a right to kick you out. You guys didn't sign a 10-year agreement or anything, did you? He has a right to kick you out.
Everything is perfect.
All right, well, that isn't good enough.
I understand that part. But he still can't change the last and throw me out without evicting me.
You didn't do that, did you?
Yeah, he did.
Who's he?
My brother. I told him
You guys are trying.
Complaints against.
You guys are trying.
Destruction of property. I'd like to let you see if you know what you see.
You guys are trying to be your own lawyer. That never ends well. Never. Oh, how do families get this angry at one another? I don't get it. You have to heed my advice. You cannot represent your father. He seems completely competent to me, by the way. Why don't you have a seat, Mr. Don Pitaway Jr. in the back? And Don Pitaway Sr., would you like to stand at the podium, or would you like to have a seat at the council table right there?
I don't know.
No, I'm just asking you how you're going to feel more comfortable. You want to stand or you want to sit?
Well, probably sit, I guess.
Sit. Why don't you sit down? You're not getting anywhere with me, Ronald Pitaway. $50 a week on Churchill and Brownstown, that's a pretty nice area. Will you move me in for $50 a week? I'm just kidding.
No.
I don't want to hear anymore. This is silly. Do you also live on Maple Lane?
Yes, I also live on Maple Lane.
And why do
I had to move in there because they changed lots on me. Well, some of my buddies, when his dad died, emptied out his house. They lived on Sutton Farms. So I was helping him. His dad had a hoarder.
You have, I'll tell you what I'm going to do.
They got a washer, dryer, a hot tub.
I don't even think I have a triable issue now. I really don't. I have to have a triable issue. I'm telling you right now, Don Pitaway Jr., don't stand up at that podium again and act like you're representing your father. Do you hear me?
I understand.
This is kind of all coming back to me now. I'm adjourning this 1 week. You guys want to come in and tell me the same kind of thing? I'm going to order you out in 10 days. You want to come in here if you've got a lawyer or some legal argument to make that's legitimate, then I'm going to find there's a triable issue. So far, I haven't. I find this more sad than anything. I really do. I get this families fight, dads and sons and mothers and daughters and mothers and sons and dads and daughters, and but I don't understand it. I'm adjourning this case 1 week. If you don't come back with some legitimate legal argument other than I honored my mother's wishes that she asked me before she died, and in 2020 did some work around the house. Stop. You look like you were going to cut me off again. Then I'm gonna order you out. You want to try some other legal theories? Feel free. I'm giving you 1 week to get a lawyer to do whatever you want to do. Maybe you need to find another one down to the way senior. I don't care. June 23rd at what time, Jen?
10:30, Your Honor.
At 10:30 in the morning, and that's it. I find this incredibly sad. Good luck.
Can I get my property out of there?
I don't know what your decision is.
Well,
are you saying you want to relinquish?
like I said, that I'm gonna have 10 days, and I want to be able to go get my stuff. I got the doors locked. I have to call the police to get.
Sit down. You're pushing me. Don't push me. Now you want to stand from the pews back there and start debating why he shouldn't be able to do that? You're not the real party of interest. You got no business being here except to observe. How many times I got to tell you that? Wait. When I issue this order, this judgment, if I decide to enter the judgment, I'm still going to give you a week if you want. You guys, sir, you're going to let him come in and get his property. If I have to treat you all like children and have the police stand by and set a specific time, then I will do that. Stop. Stop acting like children.
He was there the other day and taking his stuff out.
Is that true?
Still some stuff I put my washer and dryer. My dad tries to.
Is that true?
Yes, but they won't let me.
Hang on.
They won't let me in the house to get the other stuff.
Yeah.
No.
Hang
They
on.
won't let me in the house. Mark
Stop.
He doesn't.
Stop.
Washer or dryer.
I got proof.
I'm getting tired of hearing you say you have proof. Where's your proof?
I bought the washer and dryer from Sears. It was on my credit card. Please.
How many years ago?
About 20.
You're not taking the washer and dryer, okay? You're not taking the washer and dryer that you bought 20 years ago. What else?
My hot tub out the back.
Do we have a problem with him taking the hot tub? You don't say a word, Mr. Pittaway Jr.? You have a problem with him taking his hot tub?
Nope.
What else do you want besides your hot tub?
Like I said, the freezer and the two pictures that are downstairs that Sean had stored that they wouldn't let me get access to.
What's the freezer? You have a problem with him taking the freezer?
No, it's empty.
You have a problem with it? What's the pinchers? I don't know what you mean.
Pictures. My friend stored some of his stuff there.
Pictures.
But he's got some antique.
What kind of pictures?
They're antique pictures. They were sitting on top of the freezer.
Well, you got to be more descriptive.
They're my friend Sean's. When we were moving his dad out.
You got to be more descriptive.
Two big pictures, antique pictures. He's got.
Of what?
They're just antique pictures he had down there.
I know, but are they to depict the baseball field, World War II? What do they depict?
I didn't tell you.
Well, then why do you need them so
my
bad?
friends, I need to get them out of there. And his motorcycle's in my dad's garage. They were storing it for my dad. My brother got mad, pulled the gun out, poked me with it.
Oh my God, you guys are out of control.
Listen,
Hang on. Hang on. Do you have is there a motorcycle in the garage?
They come over to get it just the other day, and they couldn't get it started, so he towed it back into the garage. They're gonna come.
Is that true?
Yes.
Okay, so it doesn't sound like anybody disagrees about the freezer. Hang on, or the motorcycle, or the pictures, I guess. Do you disagree that he can take the pictures?
I don't care. They're his, take them. We told him he can have that freezer, and what else is that, Donnie?
What else do you need?
That's everything I have. I don't know where they put everything.
Hang on.
They took my room, put stuff in the.
Mr. Pitaway, I want a list from you. So far, you've told me 2 antique pictures that you don't have a clue of what they depict. Which I guess if I wanted a picture, I'd at least know.
Can I suggest something to be just real quick about this? Say the board's done. Can I have 30 days? I'll have it out. I'll go there. My dad will go through the stuff. I'll get it out in 30 days. And if you don't hear from us, you know everything's good. But give us 30 days. I'll have it out. And then,
hang on.
Is that fair?
I can adjourn this a week.
30 days.
Why do you need 30 days? Where are you working at?
General Motors. We're here every day of the week.
You've got 1 week. Come on.
We have a trailer. I'm trying to figure. I gotta find storage and everything else. I mean,
I think Don Jr. Pitaway should stay out of this, to tell you the truth. Don Sr., can you collaborate okay with your son here? I'm talking about with Ronald.
I'd rather handle it between my dad gets.
What's that?
I'd rather handle it between my dad gets. And I'll talk to him on the phone, tell him we're coming over. And if, like I said, it's gonna take about 90 days.
Okay, hang on. What do you want to do, Mr. Pitaway Sr.?
I don't know why it's gonna take 30.
I don't either.
How do you pick up a hot tub?
You get a truck and you get some friends and they come and help you. You should be able to do that today if you want.
That's not how a hot tub works.
Okay. Well, how do you intend to move the hot tub?
Well, I'm gonna get some money. I'm gonna call people that deliver and see if they'll come back and get it. The guy that dropped it off, I'm trying to get a hold of him and see if he'll do it. And there's some people, where it's at, you kind of gotta wheel it.
He filed this May 20th. How about I'm gonna adjourn it 1 week. I'm gonna let you guys figure this out.
Okay, 2?
I'm not gonna be here in 2 and I don't wanna move at 3. Do you have a problem with 3 weeks? If I adjourn this 3 weeks?
Really sooner than that, or whatever.
I'm not gonna be here June 30th, so it's either gotta be June 23 or July 7th.
July 7th.
Is that okay?
Right.
July 7th?
I guess.
At what time, Jen?
10 o'clock.
At 10 a.m. All right, that's what I'm doing. Okay? July the 7th at 10 a.m. You guys come back. Don Pitaway Jr., I think you should probably really stay out of this night. I don't think I can emphasize that enough, and I know you're not going to listen.
No. We have a younger son, and Donnie's been taking care of him or whatever. That's why he's basically running everything. That's,
All right.
and I'm gonna be 85, and I ain't got that long to go.
I mean, and that's what exactly my point is. It's a sad commentary. You guys are fighting like this. Jeez. Look, I'm gonna move this.
I don't hate my son. He just acted up a few times, that's all.
Okay. I would hope that you guys could resolve this. Really. I don't want to.
We did the other day, but let's just see what's happening, so whatever.
Be nice.
Get all this stuff out of the garage.
If this is you and your brother fighting, let this be you and your brother not seeing each other, but stay in touch with your dad. July 7th, come on back here. You guys see what you can work out in the meantime, will you? I really mean that. Good luck. Don Jr., maybe you should stay out of this.
No.
But don't come up to the podium again, sir. Did you hear what I said? Yes?
Yes.
Okay. See you in 3 weeks. Good luck. Fadabi Bell versus Tamisha Bell. This is 25-02024. Mr. Asphalt, which one do you have? Do I have other files?
There's 2 for 10:30, Your Honor.
Okay, within it, Eddie Davis.
I would, Judge, it's a motion for an investigator.
Is this is, okay, the defendant was charged in 25 CR 362 with the first degree felony of murder. And were you retained or?
I'm court appointed. That's right. He was determined to be indigent at the time of the arraignment in jail.
You have a motion for authorization to expend funds for investigator? Is that what we're here for? And what are you asking?
Just normal.
Is there anything normal anymore up here? So how much, what do you need? And if you just articulate what is in for you.
$2,500, I believe the investigator that his license.
Yes.
There's a number of defendants. There's also a number, there's a large amount of witnesses, a large amount of people that we call to law enforcement that need to be tracked down. Also social media, which was about other things, allegedly tying the defendants in this case. So I need some assistance in order to try to figure this out.
All right, anything from the state? No, you're having no objection. The court will allow reasonable allowance for investigator fees. 500 in this particular matter. How many other co-defendants are there?
There are, there's one, Your Honor, and then a couple other were involved with tampering.
Say that again?
There's one other shooter, and then there's two other individuals that were charged with tampering out of this separate individual.
Okay. We also have
the hospital staffs. Excuse me, three.
We have 3 full cases, right? Along with the murder, there's also deadly conduct. Are you handling those as well?
Yeah, I think they're all going to work out. That comes along.
Okay. All right. Anything else on Mr. Davis?
No, Your Honor.
What's the next event?
I believe will be an announcement somewhere down the line.
Set announcement 2 months. 2 months. Announcement. Okay.
I think it's 2 weeks.
Cedric Davis.
That's the same judge. This is a capital murder.
Different kind of case.
Different case. This has to do with a lady that was killed for auto burglary. There's 2 other defendants. Especially, I think that my client is
just one
capital murder. I think the shooter is the most death penalty. It's Mr. Coleman's case.
That's correct, Your Honor. I'm standing in.
Here's the other case on Arnold. I'm sorry.
I need an investigator one to do a background check on Mr. Davis and reference.
Is that the right one?
No, have we done this call yet?
No, I haven't done.
Okay, yeah, we haven't done that yet.
We're on Cedric Davis.
I need an investigator, Judge, because of the nature of the offense and the possible punishment, though they're not going after death penalty, to seek family members and other things involved in this case.
I don't know. I'm not showing a formal motion on this.
I should have one.
Let me look in the file. Hold on, Judge.
I don't have one in that's capital, 24 CR 2293. And then we have a motion to revoke probation of state jail charge.
That's the least of his problems. I can take care of that anytime.
You see it if I could say, Mary,
when can we do that? Today? That's introduced. Now to move.
Mr. Goldman's not here.
Oh, he's not here. There are administrative.
That's all. Yeah, the main one is the new offense that you may not want to get into. Or they.
We can work around it because it's not 5 or 6 violations. We could just move that out of the way later. So why don't we see that for a week or 2? 2 weeks. And she says there's no motion on file for investigator fees. You get it and I'll sign it.
Thank you.
You're asking for the same amount. Okay. That's before. Thank you. It will be done.
I saw what I don't have my file. I walked out. It was on my desk, but I'll get it to Lacey.
Okay. Eric Martin.
Same thing, Judge. This is a murder that happened in Jefferson County.
Are these all 3 different ones you're handling?
Yeah, it's a little bit. Yeah, that's what you said. Okay.
There is a motion for authorization to expend investigative fees.
This one extends into, I believe, somewhere in Lafayette, Louisiana, where my client and probably the deceased was located. But it started in Jefferson County. And there's some questions and reference to how the person ended up deceased. And I would ask for the $2,500.
Okay. And the defendant is indicted with murder on allegation 1, but had 2 prior convictions, felony convictions, which would enhance the punishment range if found guilty of that.
And we're just in the beginning.
All right, the request is hereby granted on this day.
And we can set that for an announcement maybe in 60 days.
I was supposed to say 60 days, but I was
Okay.
the other one.
Done.
I'll get right on it.
Thank you.
And I have told you all.
See if you can do this with a straight face.
Mike, you want
I've already had one of these motion to compel hearing before.
Right, when we started. Where's? Oh, it's an add-on. Okay. I see. Yeah, I couldn't find the name. All right, 22-40127, Cody Arnold, that as well as a
No, Your Honor.
murder case?
This is a murder case. And we're preparing. Hopefully, if we can't settle this, we're ready to go. It should be coming up fairly soon.
August 11th.
August 11th. I have 2 motions. One is a motion to compel, the other one then, if that fails, is a motion to compensate.
Go on.
Your Honor, during the investigation, I received discovery from the state that was in DVD form. I have no way to use an old DVD because of technology. I requested the district attorney to burn it onto a USB, and they said they could not do it.
What can be done to get it into a format that he can use?
Well, what he can do is he can do what I do, which is to get an external drive, you plug it into your laptop, and you can pop the disk in and look at it. He's had these disks since 2024, and we don't want to start a policy where if defense counsel makes an additional request that we put it in the format that they want. And he's had this, like I said, he's had
an request this, but it just needs to get into a format he can use.
Right.
So
as I said to the judge, I've asked for funds then to get this external, whatever it is.
Well, how much does something like that cost?
Approximately $50.
I
looked it up on Office
I would buy a first class one, but they're not a
First class is $60.
So that I could.
Can you go acquire one and we'll reimburse you as long as it will be, can you tell the court first what it's going to cost?
Sure.
I don't want to go do it. If you'll do it. And if it's just $50, I must say, I don't use one.
The highest price
one, so I couldn't have told you what it cost.
The highest price one on Office Depot is $61.99.
I've never had a problem. There are other counties that are antiquated or antique or whatever it is and do DVDs, and then they turn around and put it on zip drive. And so for judicial
just because if they can get something that will fund you a reasonable fee for that.
Beneficial for him in the long run. We have mixed media all the time. Sometimes we have USB drives, sometimes it's discs. It's like I said, we don't want to start a policy where we.
Would you be so kind to acquire that? The funds will be readily made available as long as they're reasonable, and it sounds like it's less than $100. Then
yes, sir.
I'm always kind and
just don't get a gold plated one.
I don't think those are named.
Yeah. Okay.
That's fine. I will fax your office over what I found. Maybe Mr. Ham can.
The next event.
Get one for me.
Let me.
August 11th, Jeff.
Yes. And
I'll review in 2 weeks on this, getting this stuff done.
If I have the order, Judge, we can maybe forego that.
What order?
I mean, if I get one and you approve it, I don't need a review. No, because I'll be ready for August 11th if it doesn't.
All right. Done. Thank you. So the next event is August 11th trial.
Yes, sir.
Okay. Thank you. Anything else, Tom? No. Elijah Green? Don.
Ready to go see there.
Thank you. Elijah Green, Tommy. Thank you.
Judge, I'm going to recommend you.
That's fine.
And so you want.
No, you can do happy birthday week. You should have seen.
Yeah. How are we doing?
Presentation on this since we a year old. Say before you were. Worth competition thing.
Thank God. I know someone older than me.
Always continues.
Yeah, for a long time. And please see this lady. She's going to get a fingerprint from you, sir. Thank you. Thank you very much.
Please start, Robert. Lift yourself to that. Yes, sir. Do you have your right hand side? It's right there. I mean, darker than that. Maybe that's. Do it right here. Okay.
And we now call cause number 24 CR 1316, the state of Texas versus Elijah Kashan Green. That's you, Mr. Green?
Sir.
Present with Mr. Deuster, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 14th, 2024, in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you're charged with here, sir?
Yes, sir.
You're facing a second-degree felony, which means a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years in length, fined $500, ordered, among other things, in probation to return or pay back restitution in the amount of $1,338.16 to Eagle Landings Apartments in Beaumont. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Have you pleaded to, sir, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The dentist, pick up that phone right there. Thank you. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is the pre-sentence report waived?
Yes, sir, it is.
Oh, anything else to add?
No.
If not, I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. So, ma'am, there's a big sign that says, don't bring a phone in. Now, I know everybody's got them, but when you're waiting, say it, interrupt another time, I will hold you in contempt. I'm trying to make orders here. There's a big sign that says, don't bring it in. We know everybody's got one, but when you're interrupting me again, Miss Rude, you think it's funny? You do think it's funny? Go outside. Go outside. Go outside. Go outside until you can learn some manners. Thank you, Miss Rudeness. And also follow the rules. Follow the rules, please. You were pleading guilty voluntarily. Yes, see what goes on in here? You don't need to be in here. You need to be living your life out there and doing good things.
Yes, sir.
You're pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You were placed on regular probation for 10 years. Do well. We will shorten it.
Yes, sir.
You must pay $500, a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. You must pay restitution also in the amount of $1,338.16 to Eagles Landings Apartments in Beaumont. I guess the complainant here was affiliated
That's correct.
with the with that entity. Do you understand what has happened today, sir?
Yes, sir.
All right. Fix this.
Yes,
You can fix this. See the probation officer. Thank you very much. How long, Elijah, how long will it take you to be able to pay that restitution back, do you think? The quicker you pay it back, the quicker you get rewarded. You know what I mean? Okay. Please see that probation officer when he's ready. Thank you. Yeah, and in this other case, she's got the phone up in front of her face. I mean, you don't know if she's recording or what's going on, which is another reason why you don't. Everybody's got phones in here, but you just keep them secreted and don't secret and don't wave them around. And certainly, there's a big sign that says don't do that. Bring a phone in. Ashley McKinnon.
She's a desk, so we need to bring her out. So
Well, James Robertson, Langston Adams is now the attorney for that one.
He asked for that to be set for a couple of weeks since Jim's hired on it.
Okay, on 25 CR 501 and 502, James Lee Robertson, Mr. Adams, Langston Adams has been retained on that, and he's asked for an announcement time period, so that would be fine.
Raise your right hand, please. Swear or you swear or affirm to tell the whole truth and nothing but the truth, so help you God? You have to say it. Yes. Right, come straight. Place it flat right there. Ink it up again. Place it there. Okay, and we'll make my judgment.
And thank you very much. Okay, 25 CR 292 is now called. Ashley McKinney, that you, ma'am?
Yes.
With your attorney, Mr. Dusner, and the state's attorney does the defendant. We have a formal reading of the indictment and the arraignment here. Can we proceed in a summary basis? Yes. In summary, this indictment alleges that on or about January 24th, 2025 in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you're charged with in the indictment? Yes. Looks like an agreement has been reached where you would be pleading guilty to the lesser included Class A misdemeanor of theft, which carries with it up to 1 year in jail and or up to a $4,000 fine, correct? Yes. Okay. It's 1,000, isn't it? 4,000.
4,000 on Class A, Judge.
Yeah. So do you understand the punishment range, man?
Yes, sir.
An agreement has been reached. Well, you have a real animated signature.
It's pretty big.
It's an agreement has been reached. What's the agreement?
1 year county jail, probate for 2 years with a $200 fine. Which you're quoting.
She's in custody because of a failed drug test. The concept is to get her some drug treatment.
Okay. All right, so the agreement states that you would be placed, sentenced to 1 year in the county jail. That would be suspended. You would be placed on regular probation for 2 years. Fine for $200. Was there any restitution here?
None, Your Honor. The items were recovered by my memory.
There would be terms and conditions of probation, which are normal and customary for that. Also, the probation office will do some research and determine what type of substance abuse issues you may have that we can address that will help you complete your probation successfully. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this lesser included Class A misdemeanor of theft, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty of this lesser included offense? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tended and no, without objection admitted. The state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1. It's made a part of the record for all purposes. Pre-sentence report is read to you. I'm going to follow this agreement if nothing further. I'm going to find you pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I now find you guilty of this lesser included Class A misdemeanor of theft. And I'm following this agreement. You are hereby sentenced to confinement in this county jail for 1 year. That's suspended. You are placed on regular probation for 2 years. You will be fined $200, and there will be other terms and conditions of probation, which are not only normal and customary for this type of offense, but also we will add substance abuse treatment, which will help you successfully complete this probation. And thank you. Please see the probation officer. Good luck, man. Two cases on James Lee Robertson, and those have been reset, I think. Okay. Next is Terrell Hope.
Judge,
What are we going to do?
I'm asking for some additional time, Judge. We
Placed on the trial docket. We've done this too many times.
Go ahead.
That's right. Placed on trial docket.
Is that what you want?
Yeah, that's fine.
It will be placed on the trial docket. The Mond Porter.
Judge, we place that on trial docket as well, please.
State need to be heard on that? Sir, the state needs to be heard on the Mond Porter. Those are going to be set on trial docket. Knight.
And Judge, Mr. Kimler called me. He happened to be in another court this morning. He said he could be here at 1 o'clock this afternoon and we can hold it. If not, he said we'll just place it on.
Let's see, it's in Maximus. What did he say?
So we can hold it until 1 o'clock if we want, or to place it on the problem. He wasn't.
What state say? Is there a chance it will be?
Right, I have never talked about it since the robbery was filed.
Okay. Well, let's hold that one over.
Yeah.
Xavier Aguilar.
Or not, but he is not able to give me a straight answer on whether he wants to proceed with trial or whether he wants to take the office and stay.
We can bring him out, Judge.
He has expressed that he would like to sign and doesn't want to go to trial, but he's not able to sign today.
Mr. Aguilar, that's pretty cool. I see. He was evaluated in April.
He's also current, actively taking all of his medications with him.
Mr. Aguilar? And next is all the state of Texas versus Xavier Ian Aguilar. And that's you, sir?
Yes, sir.
In 24 CR 1941. And earlier, there was a question about competency, which has been resolved. Dr. Edgar Pond, you met with Dr. Edgar Pond, remember? And he evaluated you, and you are, like everyone else, unique. Everybody on the planet is special and different. And you, though most importantly, are competent to move forward with a trial. This indictment alleges that you committed the third-degree felony of assault on a public servant, which would normally carry with it a third-degree felony if convicted no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 could be assessed. However, there are, it looks like in 2020, you were finally convicted of illegal possession of a controlled substance in 2020 out of Montgomery County, Texas. And then thereafter, after that was final, it is alleged here that you committed another felony of illegal possession of a controlled substance out of Montgomery County, Texas. So if all of this is true, the way I'm reading it, correct me if I'm wrong, you, if convicted of this new offense of assault on a public servant, which is, you would be looking at no less than 25 years in prison,
That's correct.
up to life imprisonment as what we call habitual felon. So it's very serious. And Ms. Minaldi has been appointed to help you. She's very good, a very good lawyer. Please heed her advice. You can make your decision. It's your choice. It's your life, like everybody. But she gives very good advice and works hard for her clients. Now, I thought there was going to be a resolvement in this case, but maybe I thought wrong.
Judge, we had offered something substantially lower than the 25-year minimum, I believe 7 years. Yeah. And we're being told that he wants to plead, but he doesn't want to do it today, or he's got some reason why he just feels like he can't do that today. And frankly, I'm considering just pulling the offer entirely if he's just going to keep messing around.
Well, like every Mr. Aguiar, in all cases, most cases are resolved by agreements between the parties, plea agreements. And
I don't feel appropriate considering the statement that he clearly described, Your Honor.
Wait, hold on for a second. Just listen to me first, okay? And then so we don't speak over each other. Did you hear? There's an offer that's been made to resolve this case for 7 years imprisonment, and it's your life, and you get to decide and make sure. You think that you don't feel pressured, but everybody has to, they can't just dwell on it. You've got to make a decision because that's one direction it heads in. Now, he's just stated that he's considering withdrawing that agreement and then just moving forward, I guess, for a trial. And they can do that if there's not an agreement reached. So it's your life and it's your decision. And that's the way all plea agreements work, is an offer is made. The defense considers it. Most cases are resolved of that way, but not all of them. And that's why we go to trials. And it's just when there's what we call habitual felon status, where you're looking at a minimum of 25 years in prison, that is just, you just please think long and hard about making the right decision and considering the advice that you give, because you don't want to make the wrong decision. And it's your life. You get, just like I do, make decisions. But he said that's the offer that's on the table. I think Ms. Minaldi has discussed that with you. Just let me know now, because this is the time. This is going on a year since this was indicted. What do you want to do? Do you want to accept that offer, or do you want to go, which is your right, deny that offer, and then we'll just set it for trial? What do you want to do today? It's your choice.
I would just say, I want to accept the offer under innocent.
What do you
think? Not guilty, sorry. So
Wants to accept the plea offer by pleading not guilty.
You mean no contest? That's a no contest is what some people do, where they are pleading no contest to it and accepting the punishment, and then the court will make findings based upon evidence that's presented that I would never find anybody guilty unless the court or the fact finder, the jury, determines beyond a reasonable doubt. But some people don't like to plead guilty, but they will accept the responsibility, plead no contest. And if that's done, it has all the legal effect. It works like a plea of guilty, only it cannot be used against you in any other legal proceeding, like a civil suit against you. If somebody sues you, for example, out of this. That's the big difference. But some people, it's rare, but some people plead no contest, and evidence is presented to support the elements of the crime, and the court finds the defendant guilty and moves on if there's enough evidence. And generally, there's always sufficient evidence. But there are three pleas that can be made: guilty, not guilty, or no contest. Guilty and no contest will dispose of the case without a jury. Not guilty, unless you want the judge to make the decision, we will put it on a trial, set it for trial. And then the state said, is inferring that you're going to be looking at a minimum 25 if convicted. And it's your life. You get to decide which direction it heads in. Do you want to accept the offer and you can plead guilty or no contest? And then that would dispose of the case for the agreement that had been reached between the parties. Or let's put it for trial. Your choice. What would you like to do? I know you've had a chance to think about it, and this lady's very nice. She works with defendants all the time, and she makes sure that you are clear in your understanding of what's going on here. What do you want to do?
I would take it to trial.
You want to set it for trial? Okay, it will be done. Do you understand? If found guilty, the minimum sentence is 25 years in prison. Do you understand?
Yes, sir.
Okay, all right.
Judge, I'm requesting a attorney from the will be appointed to represent the trial.
It's his choice. This she can handle this trial, but it's probably. Do you want this to move quicker and get this done quicker?
Sure.
Okay, then I find good cause to release Ms. Minaldi, the next lawyer on the trial docket wheel, and I presume you were unable to hire a lawyer. Is that correct, sir?
Yes.
Then the next lawyer on the trial docket wheel will be appointed to represent you. You make sure that there's an indigent affidavit on file here, because I'm looking real quickly. I don't see one of all the things that are filed. I don't see them.
People have no electronic investment.
I don't. You're going to. I see something that was signed on 11/7, which reflects the defendant is your only income is Social Security.
I don't get sure.
You don't even get that. It said you had Social Security of $900, but you don't even have that. You don't have any income at all, sir.
I haven't.
No income. Okay. Court will then find just with what's been on file that he signed is still completely, it satisfies indigency, and those orders will be made. We will set this on the trial docket as soon as possible. And do you understand? We've been talking about this. The state has withdrawn their offer of 7 years, if that's what you're going to do. Do you understand you're facing a minimum of 25 years in prison if found guilty? Now you're presumed innocent.
So yes.
You understand all of that clearly.
Okay.
And this is what you want to do.
Yes, sir.
All right, it shall be done, sir. Okay. Mr. Aguiar, and that's it for him. I've got David Booth.
He's a plea judge.
David Booth next, please.
He'll need something to recommend.
Please take us favorably. Something about everybody. You hate to see somebody walk off a cliff.
And Judge, for Mr. Booth, it's going to be a plea to 25 ZCCR 0395 and a dismissal of
Robert.
1884.
Come forward, sir. And go in front of that lady first. She will swear you in. Thank you.
Raise your right hand, sir. You swear or affirm to tell that's the truth, you got. If you have your right on track. Is it flat here? Okay, you can open one. I gotta get it darker than that because I'm seeing this. And then when you put it down, don't roll it, just look over here. Not roll it, just touch it. Bye. Okay, better. And you can see from touch.
All right, we now call 25 CR 395, the state of Texas versus David Booth. You're Mr. Booth? Does Ms. Now that you're attorney and the state's attorney, there's two cases here. 25 CR 395. This is a second degree felony of fraudulent use or possession of identifying information and items. Then there's 24 CR 1884, a robbery, a second degree felony of robbery. It's my understanding you're going to be pleading to this fraud, second degree felony of illegal possession or use of identifying information. And then the robbery will be dismissed as part of this deal. Sir, right? Okay, good. We're on the same page. Does the defendant waive a formal reading of this indictment in 25 CR 395? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about February 7th, 2025, in Jefferson County, Texas, you committed a second degree felony of the fraudulent use or possession of fraudulent documents identifying information which includes TWIC cards, credit cards, debit cards, driver's license, health insurance account numbers, all without the consent of the rightful owners. Do you understand what you're charged with here, sir?
Yes, sir.
This is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. There will be restitution to the complainant in this case in the amount of $1,800. When can that be paid back? How long would it take you to pay that back?
I haven't tried to say it.
Do you have one?
I have one lined up.
What is it?
Market based.
Okay. And how much do you make over there?
I haven't started yet.
But do you know how much you would make?
I think $8 an hour.
$8 an hour?
Yes.
Okay. And as part of this agreement, the robbery case 24 CR 1884 would be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney or the contents all true and correct? Yes. State's Exhibit 1 is tendered into evidence. Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea and it's freely been voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. So help you God. Correct? State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived. Yes, I'm going to follow this agreement and find you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But David, I'm not going to do that. I'm going to place you on deferred or unadjudicated probation for 10 years. You do well, it will be shortened to 1/3 of that. Yes, you must pay restitution back as soon as you can. Yes, the quicker you pay this back, the quicker your case gets dismissed. Yes, of $1,800, there will be other terms and conditions which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 20 years in prison. We don't want that. Okay. Do the right thing. Fix this. You can do it. And talk to the probation officer. Thank you. Let's see. We got a dismissal here. I guess we can see the top of the Okay, 1884 has been dismissed on Mr. Booth. Okay. You have something else?
You have a lot more, Judge.
You have one more. Watisha Jackson?
She's been declared incompetent by Dr. Durpon. Judge, I'm going to be finding her.
Do I need her out?
I don't think so.
I don't think so. In cause number 24 CR 1903, the state of Texas versus Watisha Jackson, the defendant is charged in the state jail felony of fraudulent use or possession of credit cards, debit cards, fraudulent credit cards. In this case, the defense has suggested that the defendant may be incompetent. That in an abundance of caution, the court ordered Dr. Ed Tripon, licensed psychiatrist here in Jefferson County, Texas, to evaluate the defendant. And he did that in his report dated April 25th, 2025. He has deemed that she is seriously mentally ill and needs and requires treatment for her as she is incompetent to progress to a resolution of her legal issues, and thus a treatment is necessary to enable her to reach competency in the future. All right, any objection to these findings by anyone?
None for the state, Your Honor.
No, Judge.
And this will be. No, I need state's exhibit. I need of course exhibit. States. Thank you. Okay. On this date, court's exhibit number 1 is Dr. Edgar Khan's report. It will be sealed and filed in this record, and we will review it in 4 months to see the status of Ms. Jackson's competency. And so that will be placed in a suspended state, and hoping that she becomes competent. Jesse Pond, or Pond.
Judge, I have received an offer on him today, but I'm still waiting on media for him until I have a 4-week reset.
This is 25 CR 334. How much time?
4 weeks.
Oh.
Yes, Judge. That's also something that
Look at these priors. We want to do that. Cold chill went up my spine. It is alleged that the defendant committed theft. And of course, under this Texas law, if someone has 2 or more prior theft convictions of a misdemeanor court of record or greater, a felony, then 2 or more, you commit a theft. I say you steal a pack of gum, it would have been a fine otherwise, but now you're looking at up to 2 years in the state jail if you have 2 or more.
And Your Honor, actually, the state can enhance this to a 3rd-degree felony.
I'm looking at 12 prior theft convictions here. Not 1, 2, 3, but 12. And 1, 2, 3, 4 purport to be felony courts. Walker County, Jefferson County, and Fort Bend County. Okay. All right. So, what's next?
I need more time to work out a resolution. I'm trying to make sure he's aware of his potential.
He doesn't need to come out and do anything. Sometimes when I talk to them, they understand things, but what's the state planning to do so that
We are going to give him another announcement, and if he doesn't want the offer after the next announcement, we're going to enhance it to the 3rd-degree felony. Yes, that's correct.
you'll pass that information on to him? Okay. How much time?
4 weeks.
You've got 4 weeks. Okay.
Thank you, Judge.
Yes, ma'am. Blake Ritchie?
Yes, Judge, that's another one that I have not received media yet on. It was oversight from my office. They requested it today. Mr. Boyd has advised me that there is a flash drive associated with it, so I should have that soon. If I could have 3 weeks on him.
Okay, that is granted. And 3 weeks on Blake Ritchie for an announcement. Tyrese Simon.
He's a sentencing, Your Honor.
Tyrese Simon, please. Thank you. And then I think there's one more, Mitchell Sylvester.
He wants to be set on the trial docket, Judge.
Okay, we'll bring him. Now we can call 23 CR 1657, the state of Texas versus Tyrese Simon. That's you, sir?
Yes, sir.
Present with Ms. Manabi, your attorney and the state's attorney. Does the defendant, I'm sorry, earlier in this case, you were charged by an indictment handed up by the grand jury on October 11th, 2023. It's more or less over a year and a half ago, charging you with the 2nd-degree felony of aggravated assault with a deadly weapon. And then you entered a plea of guilty March 17th of this year. And the agreement stated that whatever sentence shall not exceed a cap of 10 years in prison. A pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it?
Yes, sir.
And are there any corrections or changes to it?
Not to my knowledge, Judge.
Yes, and there are no changes, Judge.
All right, then it will be made a part of the record for all purposes without changes. The agreement, what was the date that this was into, please?
I believe you said it.
March 17th.
It might be in my.
I don't think so.
Hold on, it might be in my retreat. Let me look.
It's not, yeah, March 17th is not a date that I'm showing.
It's in my retreat.
I don't know what that means. Reprieve, that's to get something back.
It's also a pretty
Going
dog, actually.
like a retriever,
Yes, sir.
a golden retriever, Chesapeake Bay.
Well, I have them in my report.
It's a good dog, Judge.
They're the dogs, good smart dogs.
It'll actually be under February 24th.
So then, what we were looking at was like two options.
Yes, sir.
Second degree felony, aggravated assault, no less than 2, nor more than 10 years confined and imprisoned. It would have been up to 20, 2 to 20 is the punishment range for a second degree felon, but your attorney was able to limit the exposure to a maximum of 10 years, but it's 2 to 10 years in prison. Also, you could be placed on deferred or unadjudicated probation, actually, which could be up to 10 years in length, where you would not be found guilty. It would be a form of probation. Regular probation is a third option under law, but it is not, you're not eligible for it. Whenever a deadly weapon is used in the commission of an offense, then a court cannot, the judge cannot grant regular probation. So a pre-sentence report has been prepared. There are no objections to it.
Correct.
And it is made a part of the record for all purposes. All right, Ms. Minaldi, on behalf of the defense, you may argue on his behalf.
Yes, Judge. Obviously, we have an option that we are advocating for today. We would request that he be put on deferred or unadjudicated probation for this offense. As you'll note in the pre-sentence report that you have in front of you, and that's been made a part of the record, he has no felony convictions or really any felony issues that he's been charged with as an adult. He has a support system on his behalf, and I do have 2 letters from his family members if you would like to read over those as well. But he has 2 people in the audience here that are supporting him today. He has a support system at home. He has an uncle who's willing to help him find a job and kind of get away from the lifestyle that he was wrapped up in down here. At least through my conversations that I have had with Tyree in the jail, and since all of this has happened, he has grown very aware of real consequences and real adult consequences, especially since being in the jail. He has expressed a desire to change and rehabilitate and be a law-abiding citizen and a productive member of society. So given that he does have no felony convictions yet and he has not had a real opportunity at probation, I think that he has spent a lot of time in jail awaiting this point that has given him a different outlook on life. And then from there, he knows what he needs to do to be successful on probation, and he should be given an opportunity to be successful on that probation.
Okay. Okay. Abstain.
Your Honor, this is the 8th individual out of 10 or 11 that are going to be coming before you about this fact pattern. You have previously sentenced the 7 before. Each have made similar arguments like what was done here. Some were actually situated a little bit better than Mr. Simon as far as the fact pattern is concerned. Each of those individuals received pen time. Two of them were on probation at the time, and after motions to revoke probation, either hearings or not, one was sentenced to 20 years. That was Mr. Michael Williams. James Foxwell was sentenced to 15 years. You've sentenced Beatty to 10, the two Petrie brothers to 10 years, Charles Johnson to 8 years, and Deion Brooks to 8 years. I read nothing in this report that suggests that Mr. Simon should be treated any differently. The video you've seen on multiple of those sentencings is that if you, I need to know if you recall it. If not, I'd like to play it for you.
No, I remember it, but I want to.
The specifics about Mr. Simon is that PSI, which is not objected to, tells from the police version that he was striking Mr. Jefferson with a closed fist while carrying a handgun. He is not accepting responsibility fully today. He denies having a weapon. Now, I think that's probably because some of the other defendants that were sentenced were able to get less than 10 years. They got 8 years. And I think factually how that played out is they were not in possession of a weapon. They all collectively acted as a mob in assaulting Mr. Jefferson in one of the more disrespectful acts that we've seen in court as far as the video is concerned. And I know you've got other colorful ways to explain it. The amount of lawlessness that occurs here at 3:30 in the morning in our county is really it's disappointing at best.
Normal people are asleep or at work.
So, Judge, I'll need to make arrangements to get that video ready for you. I had hopes that you would recall it, but we can do that, Judge. I just need to make arrangements to do that.
I'll see what this says. I just want to confirm it with the video. I know what this says in the pre-sentence report, which says he admitted involvement in the altercation, but claims other subjects were the ones in possession of firearms, not him. However, where does it show? I'm going to get this. Mr. Simon, according to probation, was wearing a white t-shirt and green shorts, was striking Jefferson with a closed fist while carrying a handgun.
If you'll give me a few moments, Judge, I know I've got some trial copies of, because we have two defendants that are set for trial. I've got some trial copies of those videos upstairs, and I can get it shown.
Is there anything you want to say? Mr. Simon, this is your time, your life.
Yes, sir. I just want to say that these 11 months, I was going to have time to think about it. I just been running through my mind every day. What bad decision I made.
What was your bad choices?
First, being there, and then second is striking. Just involving myself in the situation.
Were you or were you not carrying a firearm?
No, sir.
Okay. We'll see what the video shows. But this states that you pleaded guilty to striking the victim about the head and the body with your hands and feet. And this states you used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. I'm going to remind you, you pleaded guilty to that under oath. Did you lie to me? You must, because these are the elements of the crime. That's what you pleaded guilty to. And here, this states, we went over this. There's your signature right there. This states, I am mentally competent to enter my guilty plea. It's freely and voluntarily made. I have read the charging instrument, the indictment. My attorney has explained it to me. I committed each and every element alleged. I give up my rights to pre-sentence report. I am guilty of the offense and any lesser included offenses. I swear all of this is true. So help me God. Let me repeat once again. You swear all of this is true. So help me God. I've read the indictment. My attorney has explained it to me. I committed each and every element alleged. One of these elements that you admitted is you did then and there use or exhibit a deadly weapon, namely a firearm, during the commission of the offense. Did you just lie to me? Sir. That's what you're doing. You said you committed every element. She went over. She's a good lawyer. She goes over these things with you. One of the elements is you used a firearm during the commission of the offense. I'm not saying that you even struck or stuck it in the face of somebody or shot it. But when you're brandishing a gun and somebody sees it, it defends it. They're helpless. But this is what it said you did. You used or exhibited a deadly weapon. But you're saying I didn't even have one. now to me, which meant you must have lied when you signed this oath, which is perjurious. You commit perjury if you swear to something that's not true. We went over and we go over this real simple. I go over it with you and you sign everything, and we do it as a great precaution so that people don't plead guilty to things that they're confused about or untrue or that are untrue. But we rely on this, the truth, and you swore to it. But now you're saying you didn't have a firearm. Shame on you one way or the other. Shame on you. You're caught in a box now, buddy. I don't like what has just happened. When you plead guilty and you're throwing yourself to the mercy of the court, you fess up to everything that's true. But you don't lie about it in an oath, which you may have done. Because now you're saying, I didn't have a gun. But that's what this sworn thing. Well, I'm showing what you signed. There it is. That's your signature under oath, buddy. I committed each and every element, and that's one of the elements. You either used or exhibited, showed a firearm, which causes people to be in fear, and then they're submissive. That's what happened. Apparently, in this case, it looks like you were part of the beating, and people were beating the poor guy almost to death. But using firearms, people are submissive, and they can't compete with a firearm. But you're saying you didn't have it, but you admitted it back on the day you signed this, and we went over it. I swear all of this is true, so help me God. What's your final answer? Or do I need to see the video? Sure. Did you have a gun with you or not? Sure. Okay, let me see the video. Okay, and Judge. Then we're going to have to, he's admitting he doesn't have a gun or exhibited it, which means we're not taking the deal. It was in front of a jury. And let me see that video. Give me 5 minutes and we'll get copy upstairs. You don't have a deal with me, buddy. And juries can't give probation for. Oh, they can give probation for deadly weapon. That they can, but they don't. But but I'm not taking the deal when the truth is what's important. You can't play games, but I will ask the district attorney to look into a perjury charge for this, because you're not going to mislead me by swearing under oath that you committed all the elements of the crime when you didn't. Mm-hmm. And it's a felony offense to commit perjury. You don't want to carry that around the rest of your life. You're tabbed as a professional liar. But these are all choices that everybody gets to make. When you either make the right choice or the wrong choice, and you live by it, the right choice or the wrong choice.
Judge, if I may, I do believe we're dealing with a law of parties issue here, where all of the defendants were charged with an aggravated assault with a deadly weapon. And if another party had exhibited a deadly weapon, which is my understanding that one of them did, he would also be responsible.
A party too.
Yes. So while he may not have had a weapon on himself, he is still able to plead guilty and be guilty of that offense because of the elements of the law.
He would have to have known other people had the weapon and used it and took part in the assault.
Yes, Judge, I believe that will be exhibited.
Somehow assisted them in the commission of the offense. That right? Yes. Should have run like the wind away from that. Should have never been. You should have never been a part of this. You should have gotten away from it as fast as possible. What is he's looking for the extent of the injuries of the victim? Does anybody know?
I do not, Judge. This might be a better question for Mr. Hannon.
He was listed in critical condition, according to the reports. Does anybody have a difference? It means he almost died. Really? There's 9 of you ganged up on it? 9? Sure. You see anything wrong with that? What? And this is all at 3:30 in the morning? Yes, sir. Is that right? Yes, sir. Nothing good happens at that time unless you're working. So you were 17 when this happened?
Yes, sir.
Is that right?
Yes, sir.
7 October. You turned 18 2 months later?
Yes, sir.
That's all evidence issue. We'll take a look at the video on this in a minute.
Do you want to finish out the rest of the cases while we're waiting on that video?
What do we have?
Oh my God. Looks so bad.
Just have a seat right over there, sir. And get back. Mitchell Sylvester.
Yeah.
That be it?
Yes, so,
Okay.
yes.
Mitchell Sylvester. Thank you.
Well, you can find it, I suppose. Yes.
Oh, it's easy.
I think he's rejecting the offer and Boyd says it's revoked now.
Come on up, sir. Thank you. You are Mr. Sylvester?
Yes, sir.
You can stand right there. Thank you. You are Mitchell Joseph Sylvester.
Yes.
And your attorney, Ms. Minaldi, is here, and the prosecutor is here. You are charged in 25 CR 307 with aggravated robbery, which, if convicted, carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And also you could be fined up to $10,000 as well. Do you understand what you were charged with here, sir, and what the punishment range is applicable?
Yes.
But under the law, the punishment range is based upon 2 basic principles: the circumstances of the crime and criminal history. And the indictment states you were convicted of an aggravated robbery out of the 252nd District Court of Jefferson County in 1980. After that was final, this states, the next paragraph states, you then committed the felony of illegal possession of a controlled substance and were convicted in 1988 in this court for illegal possession of a controlled substance. And the indictment goes on to allege that after that 1988 conviction was final, you committed the offense of illegal possession of a controlled substance and were convicted of that in 1991 in the court next door. And after that 1991 conviction, 3 convictions in sequence, then it is alleged that on or about February 16th, 2025, you committed the current first-degree felony of aggravated robbery. If all of this was proven true, the prior convictions and this indictment, then your punishment range is not 5 to 99 or life imprisonment. It would be no less than 25 years, a minimum of 25 years. It starts off at 25 all the way up to life in prison. Do you understand what you're looking at in this case if found guilty? Serious. Okay, the rest of your life. I see you were born in 61. But 25 to life is pretty much does it out. Well, that's a substantial part of the rest of your natural lifetime. All right. Is there an offer pending here? Because rarely, or these habitual, we call it habitual felony cases. Often they are worked out somehow without looking at a minimum of 25 to life. But what was?
Yes, Judge. So I had negotiated with Mr. Boyd to get a 20-year offer. So the offer would be 20 years TDC, which is less than the minimum that he would see at trial, but he is still electing for trial.
And you actually, because of the nature of the offense, you would have to perform at least 10 years before you're parolable.
That's correct.
But you should be parolable, subject to parole in 10 years of a sentence like this. But if it's 25 or more, that's 10 years will pass and you're going to be serving more time if you're convicted and sentenced to the minimum 25 up to life So have you had a chance to really think real hard about it and talk to your attorney about the ins and outs about what your options are?
No, she just came and seen me the other day.
Okay. Well, I mean, did she talk to you about what options are?
She told me my options.
All right. Well, have you had enough time to think about it?
No, sir.
Well, how much time do you need to think about it? You and I are both getting older every minute. Well, how much time do you need to think? I mean, you've had to think about it since, when did you go see him?
Saw him yesterday, and then before that, I saw him a couple of weeks ago, maybe a month ago.
Okay. When was the offer presented to him?
The offer was originally 30, and I presented that offer to him.
And then you negotiated it down to?
That's correct. So he was presented with the 20-year offer to this morning. So it has been 30, and we've come down to 20, and he has not been aware of the 20-year offer until this morning.
Okay. Okay. What's the state's position on this? If it's not accepted?
It's Mr. Boyd's case, and he told me before he left to go upstairs to meet with a witness that if he rejected the 20 today, that the offer was 30.
The offer would be back to me. Do you want to go in there and think about it a little longer? Because I've got another matter, but we're going to be finished. This is the last. Do you need any more time to think about it or not?
Yes, sir.
Well, you had to be thinking about it since this occurred and you were arrested, huh? In February, right? April, May, in 4 months. But how much time do you need to think about it? Because they're giving you kind of a deadline here, it looks like.
I need another month or two.
Sorry?
A month or two.
A month? I don't think that's going to be in the game. That's not what they're saying.
I was told he has today, and I don't really have the authority to, go beyond that. It's not my case.
Any input from the defense?
I mean, I think that
It's his life. It's his life, and he makes everybody in here, you and as well as me, we all have decisions that are ours to make. And it sounds like you've been informed of what your options were. You understand what the options are. You don't have many options here. You can certainly, and you're presumed innocent. That's the way the law is. You hadn't been found guilty of the crime. If you were found guilty, the way it sits, you're looking at a minimum of 25 years up to life in prison. But that's, you were there, you know what's best, what the facts are, but the state has their position, and they're saying that if you don't accept the deal now, then it's revoked. And the only other option is we set it on for trial and you don't get the deal. You're looking at a minimum of 25. So I don't know, it's your call. But you don't have months to think about it. You've had to have been thinking since February 16th about what potential options might happen. So I know but everybody in this room has the same dilemma. They have to decide what nobody can make the choice, but the defendant, him, you, me. When I make choices that are mine, then people can give you input. Yeah. But it's your choice at the end of the day. What do you want to do?
Either way it go, I'm doing. I'm going to take 25, 20 or 30. Either way it go, I'm not coming back to the world.
Sir, I'm older than you are. And I hope to live a lot longer.
I hope
but you too, well, I'm pulling for you. But what I'm saying is that in 10 more years,
probably could.
You're not that old. I mean, you're thinking that, but it's your choice. I want
Judge
something other than incarceration the rest of you. But in 10 years, you still have, I think the average lifespan is more than that of 10 years, but maybe you're just not as hopeful as I am.
Given that I just received the re-offer of 20 years today, and he has a very big decision to make, could we request for a 1 week resetting to give him time to think on that?
Well, I can't. The district attorney's office.
I will just, for purposes of kind of what I've seen here, hold it open or ask Mr. Boyd to hold it open until that 1 week when he comes back.
I'll give you a week to think about it. But that's more than fair.
After that, it's over.
Is that good for you to think about? All right. Why don't we reset that 1 week? Okay. And we'll bring you back next Monday and we'll see what happens.
Yes.
And feel free to talk to this lady so she can answer any questions that you might have to make this decision easier to make and the proper one in your situation. Okay. All right. Thank you. Yes, sir. On Mr. Simon?
I have the
Okay.
video, Judge.
Just to make sure, we already did Kenneth Randolph and all those.
I don't have anything else.
Okay. So you don't have any others?
No.
Okay.
Just some.
David,
Thank you.
here's David Grove's cases from the other day on Katie Knight.
That's right. That's right.
It's right. He said he's gonna be here at 1.
Okay, it was David's, now it's Rives. Okay, they'll be here at 1. Okay. All right, let's, first of all, where is the defendant in this? Do we?
I was getting this copy, Judge. I was able to determine that. I'm going to play that identified stop and identify important.
Thank you.
Since I'm doing that, Your Honor, I'm going to go ahead and mark this exhibit as State's Exhibit 2, since the plea is State's Exhibit 1.
All right. Any objection? Without objection, it is so marked. Thank you.
So if you'll give me a little latitude, Judge, I'm going to play this and then pause it. By way of comment, he is supposed to be wearing a white shirt and green shorts. This here is the big one. Where the pointer is, that's Mr. Jefferson.
Who is the victim here?
I believe that this is Mr. Simon right here.
Where?
Right here where my pointer.
I'm sorry, I don't see the point. Okay, all right.
I'm going to back
This
up.
back to us?
See his
Yes.
face?
Okay.
See the face there?
Mm-hmm.
That is Mr. Simon. When the car moves away, you're going to see that he's wearing the green shorts as described in the PSI. I'm going to pause it where it's clear that the gun is in his left hand. When the car moves at this stage, Judge, and if you pay attention, this is Mr. Simon here, where the pointer is. So you got already? I stopped it.
There's something.
Point you to
Left hand.
You see the gun in his left hand. He's holding it down as the car is moving away. The assault is about to occur. You see him getting in his lips there, Judge?
Man, sauce.
Okay, good. Bring that back to the punching, please, if you do, sir.
He sticks that gun in his shorts right there. And delivers by my count at least 6 hits on the victim.
It's okay. We'll bring it back right where he's in front of, in the foreground of the camera. Victim stop. Where do you want? As he's walking right around the right fender.
Yeah.
Stop. Okay.
See how he's holding his hand? Like he's dealing with the gun there in his pocket? Have you seen enough, Your Honor, or do you want to see more?
I want to go back to the beginning of this assault, please.
Where do you want the portion where we see the gun in his hand?
Yeah, the beginning. Yeah, how the car is. At the point where the car is moving.
You want to do the VLC and zoom in?
No.
Yeah, can you zoom? Do you have the ability to zoom?
I do whenever I ask for help.
No, thanks. Probation? Yes. Yes. Hold on for just a second. You can stop that. And for you to you pull it's not fair. It's just not fair. Sport people are submissive, and when you pull it out, you're using it, and you're either going to bed or working, not messing around in a congregation. To lose by just misstating the facts from the video here that was wrong, flat wrong. You looked me right in the eye and lied to me, and that's not the way to handle it. And we don't have to be up here showing you that you're not telling the truth for you to tell me the truth. You need to be honest from the beginning of this. What this is multi-level state of problems in this town, in this county, that is struggling with misbehavior, with the 16th highest crime rate in the state. There's nothing that we're proud about, and the people who are trying to be proud in the city and do the right things are having to deal with irresponsible behavior. This is occurring at a public place, a grocery store, at 3:30 in the morning. Everybody needs to be in bed or working, not messing around in a congregation of folks, and then assaulting. And it was attack the guy like a pack of wolves. It's like a pack of wolves. And then anyone who has a firearm, anyone who is displaying or exhibiting a firearm, is only going to throw gas on the fire, because somebody sees this. It's when you pull it out, you're using it. And you're either going to use it for the wrong reason, or someone's going to shoot you. But when you pull out a weapon, the people are submissive, and you have the power over them, which you're not supposed to have. That's not the right thing. And then y'all all pounced on the victim, and there's no way he can defend himself. It's just not fair. It's just not fair. It's like playing on a basketball court and the other team shows up with 20 players and you're stuck with 5. It's not right. It's not fair. That's why sports, which emulates real life, good lessons with rules of behavior, are followed. And when you don't follow the rules, then you get it's a foul and you get punished. And the same is in real life here. There are too many aggravating factors here that all add up to problems. But when you are rightfully accused, you don't lie like you did. Others have been forthcoming. And it's not as though you haven't had problems in the past. I mean, I'm looking at putting the city ordinance in the runaway. I've got an evading arrest out of Harris County that was dealt with through the court. Unauthorized use of a motor vehicle that was, I think, dealt with in this county under juvenile matters. And then evading arrest with a motor vehicle. The point is, juveniles, people make mistakes. When you're young, you're supposed to learn from these mistakes and do better. And then after all of those situations that you had with court authorities, then on October 1st of 2023, after all of that, mistakes have consequences and you were dealt with them. And the right thing would, of course, learn from those mistakes. But here we are at 3:30 in the morning, and you're displaying a gun, and whether you fire the gun or not, it emboldens the person carrying the weapon, and it is not fair to others or being subject to the misuse of the weapon, like the victim in this case. They do not have their rights anymore because they are submissive, thinking they're about to lose their life, which is what happens when you brandish a gun. People are going to assume that death is a clock's tick away, and you're not supposed to have that power over other people. But all that being said, with all of those fires, then you get here and you lie, and we have to see the video. I wish you would have handled this a lot better and more honestly. Anything else to add? If not, I'm going to find you have pleaded guilty in this case, Mr. Simon, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in this earlier plea hearing to find you guilty beyond a reasonable doubt. Before I move forward here, is there anything else you would like to add?
Yes, sir.
Yes, sir. Go ahead.
Apologize for lying, possibly saying that I didn't have a weapon. Just I was misunderstood it. What did I use it? I have it. That's all.
You told the probation officer, I did not have a weapon, but other people had guns. They don't lie. They wrote down exactly what you told me. And that's what you told me. We had to prove otherwise. Anything else?
Sure.
I hereby find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used or exhibited in the commission of this offense. Do you understand what has happened today, sir? You will be given credit for all time you have served. Anything else?
No, sir.
That is all. I am really disappointed that this one worked out this way. I thought that you were going to handle this a lot better. That is all. We are in recess. Thank you.
All right.
Judge, could you pass this case? I'm going to be through in another courtroom here in 5 minutes.
Yeah, I'll pass the other one. Which
Thank
one
you.
is that? Which
He's
case?
got the Truman Estates.
Yeah, no problem. Your name, ma'am?
That is Tamisha Moore.
Okay, so you're the defendant. Where's Bobby Bell at?
I've not had him check in this morning.
Do you know why he's not here by chance?
Because all of this was hogwash.
He claims you owe him $35,028.90.
I do not.
Ms. McDowell, can you state your name, please?
Jaleesa McDowell.
All right, this is the people's motion.
Thank you, Your Honor. Your Honor, at this time, the people would request the court set a bond of 50,000 cash surety. I'm aware it's already set. In this case, the people originally requested a $100,000 cash surety bond, and the magistrate granted a personal recognizance bond at the arraignment. This case stems from a 911 call from the victim's friend after she received a text from the victim saying that her mother had stabbed her and that she was scared to call 911 because the defendant had been threatening to kill her if she heard sirens. When officers arrived, they spoke with the victim, who informed them that she and her mother had gotten into an argument. And from that argument, the defendant grabbed a butter knife and stabbed a wall in the house and then stabbed the victim's hand. After stabbing the victim's hand, the defendant then forced her into the bathroom and yelled at her to take off her clothes and get in the tub. The victim refused, and this caused the defendant to then grab her around her throat, shove her into a wall, which caused her head to hit the wall. The victim informed officers that she was extremely afraid of her mother and fears that her mother will kill her. And the people have extreme concerns given this case and the fact that the victim had to go to the hospital for that stab wound that required stitches. We have extreme concerns for the victim's safety as well as the community's. This defendant also has another case that was recently charged, I believe was arraigned on Friday for an MDOP against her boyfriend. That case stems from incident in March of this year where the defendant chased her ex-boyfriend in a car and was throwing rocks at his car while it was driving down the road, resulting in damage to the vehicle. So at this time, the people would ask that the court set the bond at 50,000 cash surety in the GBHFA case and believe that the personal recognizance bond was an abuse of discretion, Your Honor.
Thank you.
I've had the opportunity to meet with my client prior to today's hearing. I wasn't present at the arraignment, so I don't know what facts were argued by the prosecutor's office. The only thing new that I'm hearing since the bond was set at personal recognizance by the magistrate on June 12th is the authorization of the malicious destruction of property charge, a 1-year misdemeanor, which my information is involved rock throwing. It did not involve the complaining witness, her 15-year-old daughter. It was a separate incident in March. So I don't know what information is new that is being presented to this court. As background, my client has 2 children that are in the household, a 12 and a 13-year-old who are currently, and I stretch to say unsupervised, but I think they're in the care of neighbors and friends, and they need structure as school is out right now. My client is gainfully employed at the mobile gas station at Haggerty Road and I-94, where she's a supervisor. Also, when she was arrested, her home was not secured, and her home right now, as I understand it, is unlocked, and people are helping themselves to the contents of her home. She lives at 1243 Stamford Court in Ypsilanti, 48198. And it's my information that the prosecution has not been provided or has any jail calls where my client has made any contact or had any contact whatsoever with the complaining witness. And as the court's well aware, had they been armed with this information that my client was attempting to reach out to her 15-year-old daughter, they would have presented to the court. So boiling this all down, we have no new information other than the rock throwing incident, which occurred in March. I'd ask the court to consider a $5,000 10% bond. The prosecutor, I believe, told me that the bond for the malicious destruction of property charge that was authorized and that my client was arraigned on was set at 1,010%. And also as a condition of this, any release, this case, the instant case, any release would include release on a GPS tether. So we would have, the court would be aware of where she is at all times. And it's my information that the complaining witness, her 15-year-old daughter in this case, is not in the household. So there would be no problem with any unwarranted or any contact whatsoever. But my client needs to get out to save her job, help in the defense of this case, secure her home, and secure those 2 minor children that aren't in school. So I'd ask the court to consider a $5,000 10% bond.
Well, I thought that the other children, as I was
understood were with, that their, I guess, care had been secured.
That's my information. I have not been able to verify it. Counsel that was assigned the case this morning called off, so I went to the jail and did due diligence as required by MIDC standards to meet with my client. I can't speak because on verifying that where those children are right now, but that's my information that I don't know their supervision right now. I haven't been able to ascertain that because I had to go see my client, but I got the call from my colleague who called off.
Well, just so that we're clear, I watched the arraignment after receiving the motion. And my understanding was that the 15-year-old was with her grandmother.
Your Honor, per my notes, my other minor children are staying with the father, stepfather, and then the victim, the minor child, is staying with her grandmother. And then further notes indicate that the children were put with a brother or girlfriend who lives either next door or close to defendant's residence. So I'm not exactly sure at this time where they're staying. I know they talked with CPS, who is working on getting the grandma to be the caretaker at this time.
Okay, that was one of my questions, whether or not CPS was involved. But
And that's another concern of my client, not to cut you off, Your Honor, but with the tenuous supervision, as stated by prosecutor as well, there is a plan in place, but I don't know, kids being kids, I don't know how manageable they are. You've had 12 and 13-year-olds, Your Honor. You can't even get them to turn off the TV sometimes or come in when the street lights are off. You know what I'm
I don't
talking
know
about.
how your kids act.
Oh.
That was not my children.
Oh, okay.
All right. So, but Ms. Zenda, these new individuals, I'll call them, that these children are staying with, does that include, at least based upon what you have, that the victim or the 15-year-old is there?
I believe so.
I heard a grandmother in Detroit. That's what I thought I heard.
Well, that initially was where she was going to be, but the other two were supposed to be with, I thought, at least as what I could understand from the arraignment, we're supposed to be with the father of the middle child. But now I'm hearing something different where all three children may be someplace in the same neighborhood.
I believe so. We received an email from DHHS that said the kids were with an Alicia Clark, who is the defendant's brother's girlfriend, and the residence of the address that they're at is, can we approach, Your Honor?
Yes. Septic. Like at a brief press conference, and the major septics of the clear was the at least the last known address regarding the children that are involved in the case been put on record. That way, was there anything else from my other side?
Nothing from the people, Your Honor.
No, Your Honor, other than she needs to get out, take care of those kids. The two that she can have contact with, keep her job, and
well, and maybe that raises another concern for the court. I became aware of the MDOP after, or at least the details of the MDP after the court had made its initial decision regarding the magistrate setting a bond. But why should I permit, given what I hear, her to have any contact with children or anyone under the age of 18?
Because CPS will step in. And then that's a whole nother can of worms.
What is a whole other can of worms?
CPS investigating it. Possibly.
Correct. But typically in cases that might be similar to this, where there's injury to a child, we don't, the bond conditions are set where there is no contact.
With any children?
With any children.
If you let her out, we don't object. Put her on a tether and set her bond at 5,000, 10%. No objection.
Okay, but then I have the other issue that if she were let out, the location, at least is known, of the children are in very close proximity to where she would need to reside, which is my other concern.
She's already got a condition for release on a tether, so you know where she's at.
I don't know that it's much of an issue.
I can get another address, sir.
Okay. Don't interrupt the judge.
I'm sorry.
The concern that I have is it's not a home confinement tether. It is just an exclusion zone, which, given the addresses given, the children would be residing within that exclusion zone.
Understood. She said she'd give you another address.
Well, I don't know anything about that. I mean, maybe she should have talked with counsel about that.
Well, we don't know where the kids are. To see if there's going to be any violation.
I know, and I understand that, but I also know that as of Friday, or at the time of the arraignment, one child was one place, the other two were at some other location with someone. Now I get here today and am told that all three of them may be someplace else. Now, granted, on Friday, I did not have any information or any indication that CPS was involved. I was going to imagine that they were going to be, but I didn't have any of that information. So I don't even know where these children are at this point.
And that's why I said CPS involvement. She's fighting this case and now she got to deal with CPS too.
Well, I don't know, right? I mean, I can't say anything about what CPSs will do or not do. I just know that. All right. The magistrate setting the bond, there were a couple of things that the motion indicates, and from what I'm to understand, that there were indeed threats that were made to at least the victim in this case, the 15-year-old, both from what the court understands before and after the incident of the stabbing or the injury to the 15-year-old's hand. The bond form, the law enforcement bond form, which may have mistakenly misled the magistrate, indicated that there were no threats. However, there were indeed, or at least there were indeed threats. The other concern that I have is that there is a weapon that is used against a minor, not just in a threatening or assaultive fashion, but in a fashion which then indeed led to the injury and the necessity for medical treatment of that 15-year-old. There's further the indication that the defendant or that the victim in this case is fearful of the defendant. In looking at just those facts, the court would find that the bond as set by the magistrate does constitute an abuse of discretion with reference to a PR bond, and then simply without knowing the exact location of GPS involvement, and just a GPS with an exclusion zone and nothing more. So the court does find that that's an abuse of discretion. Knowing additional facts, and let me just say this, it's an abuse of discretion because of the alleged conduct of the defendant in this case, and that the court would consider that the defendant would then be a threat to not only the victim in this case, but a threat to the community, and a monetary bond, given those circumstances, should have been set. As we now sit here today, there is the additional information regarding this defendant and alleged activities of violence toward someone else with the malicious destruction of property claim, or malicious destruction of property circumstance. From what I am to understand about that case involves either a boyfriend or ex-boyfriend. There is a concern that the court has, given that I have 2 domestic violence incidents by this defendant, allegations or cases that are domestically involved, which raises additional red flags for the court, and also a heightened belief that the defendant in certain circumstances does indeed pose a risk to the community. Taking all of that into account, I'm going to do 2 things. I maintain the bond that the court originally set, although quite frankly, I believe that I should raise it. And that bond will be, her bond will be set in the amount of $50,000. That's a cash bond. Further, the court is going to order the cancellation of the exclusion zone tether, but should the defendant be released, certainly I would reconsider it, but I would order a home confinement tether as a condition upon her release, prior to her release, should she postpone.
When's the next hearing on this one?
Pardon?
The PCC is already set for June 26th.
PCC is June 26th.
If we get you a new address, would you reconsider before then? Or
reconsider which portion?
A 10% privilege.
I will certainly look at anything that anybody presents to me. I'm disinclined to change anything until I have some information regarding where the alleged victim in this case is, as well as these 2 other children and where they are. But at this juncture, I'm not inclined to change it.
Yes, sir.
All right.
Yes,
Thank
sir.
you.
Thank you. I'll see y'all tomorrow.
Yes, sir. 14A, in recess.
How you been, Judge?
I'm always good.
I know you are.
GPS trackers show they were at the house. I don't know what these people think they're getting away with. And you're right, Judge. We believe that they're just pulling descriptions for people off the internet in some form or fashion or off some device that gives them something close to the person in question. On this one, I can't tell the court whether he was served or not. I don't have his physical description, but they're required to provide it as part of the documents they provide to us and that we provide to plaintiff's counsel. So in this circumstance, I can't tell the court, given her history. I agree with the court. It's kind of you question it because at this point, there's a lot of information on the internet, and it's hard to verify whether or not they actually served the person or not. And the GPS, like I said, puts her at that location at the time of the service.
Well, they have reached a settlement in each case. Just because the service was bad doesn't mean that the case isn't legitimate and that there's a legitimate cause of action. Neither bill was substantially large, and in each case, defendants have resolved it. Ms. Lynn paid in full, and Mr. Lords apparently worked out some sort of settlement. So I guess as far as I'm concerned, that we can bring this matter to a close. I don't know if there's anything else to say. Mr. Varchetti, I'll wait for that order. And if it doesn't come within 2 weeks, we'll reset some sort of a hearing. If it does come, we'll simply enter it.
That's
anything else you wish to add?
Nothing here, Your Honor.
All right, thank you both. I'll call this matter closed. All
Well,
right,
Judge,
thank you very much.
Judge, I do appreciate you letting us do this by Zoom. I appreciate the
Yes.
consideration.
All right, I hate to drag you all the way down here for that. I mean, it took us about 6 minutes. She isn't here, so I don't get to express my opinion, but she's probably got a Fifth Amendment right not to say anything anyway. So we'll see where the Attorney General investigation goes with this. All right, thank you both, gentlemen.
Have a good day, Judge. Yep, bye.
All right. That's the end of that. All right, we are on schedule. It's 9:14. Attorney Jeff Werber is here on our next case, and the defendant Kathleen Tracy is here. Good morning, Mr. Werber.
Good morning, Your Honor.
Our next matter is Capital One versus Kathleen Tracy. The file number is 241919 GC. The claim is for $3,692.37. The defendant presented an answer essentially just saying, we've had some health problems in our family. I'm not working a limited amount of hours and don't presently have the ability to pay. Ms. Tracy, we have the ability to put you in what's called a breakout room where you could speak privately with Mr. Werber. He's the attorney for Capital One about perhaps coming to some agreement here. Is that acceptable to you?
Yeah, whatever you think is best, because my parents are moving in with us now, and so I have nothing to give anyone. I mean, I'm sitting in my car in the parking lot waiting to go to work so I can make some money. So I'm just whatever you think.
All right, well, let's try that and see where we go. I'm going to put you both in the breakout room. If it comes up, it'll say join. And I'll be here thinking about things while you guys are talking.
Okay.
We were, I've said this recently, scheduling these general civil motions on Monday, half an hour apart. We started scheduling them 15 minutes apart, and that so far seemed to be enough. We have a 9:15. We had a 9:30 that settled. We have a 9:45 and a 10. Then we'll shift gears into criminal cases. None of these are huge. One of them has an appearance in it. We have 3 sentences, 2 at 10:30 and 1 at 11. So we should be in pretty good shape. As the morning goes on, afternoon is going to be busy. All right, Mr. Werber, this may take me 60 seconds. I
No
got in
problem.
and changed the time on this, and then they give me a new computer. I need to go in and redo it. Here's Miss Tracy now.
Sorry, technical issues.
All right. The parties were in for just a very short time.
Your Honor, what we're going to do is we're going to enter into a consent judgment with no payment plan at this point. We did discuss a possibility of $50 a month. Ms. Tracy knows she has 21 days till we can start collection efforts. I did provide my telephone number. She wants to do the $50 a month. She'll call me. She's aware of the possibility of filing a motion for installment payments and letting you decide the payment plan. But at this point, we agreed to the consent judgment with no payment terms.
All right, well, let's talk about how much that is. The complaint requests $3,692.37.
That is correct. There's a $75 filing fee and a $52.80 service fee. So the total judgment, I'm going to do the math right now. Is 3820.17.
$38,2017. So, Ms. Tracy, do you acknowledge that you owe $3,692.37, $127.80 in court costs, for a total judgment of $3,820.17? You agree with that?
Yes.
You agree to the entry of that order without a payment plan?
Yes.
$50 a month was discussed, and that's pretty generous payment on a debt of this size, but you can avail yourself of that.
After 21 days, they can start collection efforts like garnishing your wages, which you won't like, or your income tax state refund. You can also, as Mr. Werber said, file what's called a motion for installment payments, where the judge would set the amount. Although 50 seems quite reasonable on a debt of this size, that would only pay $600 a year and take about 6 years to pay this off. But if you don't have any money, you don't have any money. And so I understand your position. Circumstances could change. So, Mr. Werber, you send this under the 7-day rule?
Yes, I will. Would you like me to just do it as an order, or should I sign her name with consent?
Miss Tracy, you agree on the record of the terms and conditions of this settlement?
Yes.
All right, you can sign her name with consent. He's gonna send it under what's called the 7-day rule, so we come and it sits for 7 days, and if it says what we just placed on the record here, you don't need to do anything, it will just enter. But if it's wrong, if the numbers aren't right or the information in it is incorrect, you have 7 days to object.
Okay.
So, a couple things. Once this comes in, you need to get a hold of the firm and tell them whether you're going to accept this $50 a month payment plan, and their number is on the information that you have. Maybe your circumstances will change, more hours at work, or your husband back to work or something. But you're right, this isn't going to go away. And so you've simply acknowledged the debt, accepted responsibility. If you at some point do wish to ask for an installment payment plan, contact the court. They can actually give you the form on how to do it. We'll set that for a hearing. Otherwise, this order is going to enter in the amount of $3,820.17.
Okay.
All right. Do you have any questions?
I do not.
All right. You're good to go. I'll release you.
Thank you.
Thank you, Your Honor. Have a good week.
Yeah, it's early Monday. We'll see how the rest of it goes. Thanks.
I'm with you, Judge.
Okay. Bye.
Bye.
All right. Our next matter is not for 20 minutes. So let's see. And then we got a short one after that.
and $157. Discover Bank versus Cindy L. Goodwin. Ms. Cindy Goodwin is here. Also, Attorney Andrea Fays is here on behalf of the plaintiff. Ms. Fays, what's your P number?
It's P76952.
This is a claim for $7,657.83. Ms. Goodwin does have a hearing impairment, and I will try to make sure that I'm speaking loudly enough that she can hear it. She sent 2 letters expressing her circumstance, including her significant medical issues and current inability to pay this. She was apparently working with a debt consolidation company, I'm not sure what they were.
Credit Associates, I'm sorry.
Credit Associates. And that didn't work out completely. Ms. Goodwin, what I would propose to do is put you in a breakout room to let you speak privately with Attorney Fays and discuss the circumstances here, see how we wish to proceed. Is that acceptable with you?
Do what now?
Put you in a breakout room where you can speak privately with Attorney Andrea Fays.
Okay.
All right, I'll set that up. Give me a minute. I'll be right here the whole time. All right, just click the button that says join, and I'll be right here. That is file number 2425-70GC. It's entitled Discover Bank versus Cindy L. Goodwin. It's a claim for $7,657.83. Ms. Goodwin is here pro per. She does have some hearing impairment, but she seems to be able to hear everything. Attorney Andrea Fays is here for the defendant. Or the plaintiff. The defendant has not really stated a defense. This looks like the kind of case that could be appropriate for summary disposition, but I put the parties in a breakout room to see if they can get close to something. Once again, I'll sit here and wait. I shut the record off while I was waiting before, and I forgot to turn it back on. So I've restated the circumstances. We are on the record now as well as on the live feed. This is. Good morning. Are you Pamela Atherton?
Yes, sir.
Which case are you here for?
For Stonehouse Apartments.
I think you're at the wrong time. Let me look. I'm going a little scavenger on here, see if I can find it. That was held Friday, June 13th, and you didn't show up. Let me look here. Do you have your notice there in front of you?
I don't have it right in front of me.
I believe the matter was set for June 13th, not June 16th.
Great.
Let me look. 251012. Casey Strong was here. The manager, Carrie Hughes, was here. You were not. They indicated that you were still living there. They made a finding that the rent is $3,115.
Right.
And there's $198.40 of court costs. So you owe $3,313.40 by June 23rd, or you're subject to being evicted.
Okay.
Let's take a look. Yeah, in a civil case, when you don't show up, you lose automatically.
Yeah, well,
so the notice was for Friday.
I apologize. I had it wrote down on my calendar wrong.
All right, well, I would suggest you go talk to your manager.
Okay.
But at this point, the clock is ticking on when you have to either pay or move.
Right, yeah. See, and I've been working with this organization called Neighborhood Inc. for 2 months trying to get this taken care of.
Well, you can move to set the default aside, but you just wrote the day wrong. You don't have a good reason for not showing up. Neighborhood Inc. is understaffed and underfunded, and they got more need than they have money.
Yeah.
But at this point, I would let your manager know that. They don't have to evict you on June 23rd, but they can.
Okay.
All right. You're good to go. Thank you.
All right, thank you.
That happens sometimes. All right, I've got Andrew Rognus in the waiting room. He's always early. He's here for his 10 o'clock matter. And we'll leave him where he is. That Miss Atherton.
He was aware that the conduct that he was engaging in was assaultive in nature. When you pull your fist back, you throw it, you stay on top of the guy while he's trying to cover up, push him down into the door. You're assaulting, you're aware that's what you're doing. Now remember we talked about circumstantial evidence, right? We don't have direct evidence. In other words, we don't have a statement from Mr. Snyder saying, I'm assaulting you, I know what I'm doing, right? You have to look at the circumstances. What was the nature of the interaction? What was the conduct that he engaged in order to arrive at, is he aware that what I'm doing is an assault? And if he knows what he's doing, and the state has to prove to you that what he did caused the injuries to Officer Hopper. Well, again, you saw the video, not just the body-worn camera, but also the block videos that show, you can see in that altercation as Snyder continues to throw punches at him, that the glasses go flying, the things that are in Hopper's hands go flying, and you see Officer Hopper before the incident seeing that he doesn't have an injury. I know this seems simple and straightforward, but these are the things I have to prove you. Those punches are what caused the injury. The defendant, I don't have to prove to you, we talked about this in, during jury selection, I don't have to prove to you that Jason Snyder intended to break his nose, that he intended to cut his face, that he intended to cause that bruising and swelling on the face. He is responsible, if he's engaging in that conduct, he is criminally responsible for all natural foreseeable consequences. You can rely on your common sense, your experience as human beings. Someone gets punched in the face, sometimes that results in a black eye, but it's also foreseeable it can result in a broken jaw, a broken nose, cuts, bleeding, bruising. Jason Snyder is responsible for every foreseeable conduct, not consequence, not just what he may have intended to do or not intend to do. The state doesn't have to prove to you what his intent was, only that he knew he was engaging in an assault and that assault resulted in a serious physical injury. All right. I keep using the term serious physical injury, but law is serious physical harm. I apologize for that. I was a prosecutor in Oregon for many years, and sometimes I still do the opposite. So the judge is going to instruct you on serious physical harm. And there's 4 things the judge is going to instruct you on. The first one is that any physical harm that carries a substantial risk of death. I don't think this is that kind of an assault. The state's not going to argue to you that a punch to the nose is likely to result in Officer Hopper's death. But the other 3 circumstances are ones that you should consider, and that is any physical harm that involves some temporary substantial incapacity. So that's the first one. We know, 1, that this assault resulted in 3 months out of work. 3 months. 3 months of difficulty breathing, 3 months of limited sleep. You have that limited but substantial incapacity. So if the defendant's assault and the injuries that he caused result in this, then that's serious physical harm. The second that you should consider is any physical harm that involves some temporary serious disfigurement, like having your nose completely smashed across the other side of your face. That's scarring, that's bleeding, temporary substantial disfigurement. So temporary serious disfigurement. Even though, a week later he had to have that straightened out, he still had to suffer that type of an injury. And the last for you to consider, and these are not separate from each other, they can all be intertwined together. They are each by way that you can find that this is a serious physical harm. And the last is any physical harm that involves acute pain of such duration as to cause substantial suffering, or that causes any degree of prolonged pain. So you've got the serious specific injury, pain, that occurs when the assault occurs, but 3 weeks of taken Vicodin in order to manage that pain. That's pain of any degree of a prolonged time period. That is what we call a serious physical harm. The second offense that the defendant is guilty of is assault on a corrections officer. Judge is going to instruct you that for the charge of assault, you must find, again, that the defendant knowingly engaged in the conduct. He knew this was an assault. He knew throwing punches is the kind of thing that hurts people. But this time the state only has to prove that sort of lesser level of injury for this charge. Serious physical injury, physical harm, I keep using that. Serious physical harm is subsumed within that. If you have the higher level of injury, it includes the lower level, okay? So the state only needs to prove for that purpose what we call physical harm, which is any injury, illness, regardless of its gravity or duration. You have that bleeding, you have that swelling, you have that pain. Certainly things that rise to the level of what we see in serious physical harm is going to qualify for a physical harm. But the state needs to prove to you the circumstances, additional circumstances. 1, that this happened on the grounds of a state correctional facility. This happened at Warren Correctional, one of our prisons here. And 2, that the victim of the assault was an employee of the Ohio Department of Corrections, which Officer Hopper is and has been for 30 years. And that it was committed by a person who was incarcerated under detention at the time of the assault, which we know that Mr. Snyder was. He was an inmate at the time this happened. You have substantial evidence from which to rely on in making your decision. First, as I already said, you witnessed this assault. You have the body-worn cameras, and you have the cell block cameras that show the circumstances of this assault. They show, 1, again, it was unprovoked. There was no use of force by Officer Hopper. This is not like a self-defense claim. There's nothing here that excuses this use of force legally by the defendant. Those videos also show the manner of the assault, that it's aggressive, it's continuous, it's ongoing until other officers intervene. You can use that information to determine the nature of the assault. Did he know what he was doing was an assault? You have the photos. You can look at this and see the extent of that injury, that this is a physical harm, that this is a serious physical harm. And you have the medical records from Officer Hopper's treatment at Atrium, which confirmed the nasal fractures, the prescription pain medications, and all the medical treatment that he received that satisfy the state's burden of proving to you that this is a serious physical harm. Members of the jury, when you retire to the jury room, take the time to review the evidence. Talk to each other. Listen to the judge's instructions. Apply the things that you have heard from the state's case to the instructions of the court. And when you do that, you will find that Jason Schneider is guilty of felonious assault, and he is guilty of assault of a corrections officer. Thank you.
Mr. McKenna?
Ladies and gentlemen, you've heard the evidence, and this is a short jury. It's not a long trial. It's quick. That doesn't mean it's not important, but it doesn't mean that all the evidence is perhaps more important because there's not a lot of it. The state can only put on what it has. It had the alleged victim, it had the investigating officer, and that's what the evidence is. And so when we were talking about in voir dire and picking jury selection, I said you got to pay attention and wait till the end, and you have. And that's where we're at now. You got to decide what happened. And the issue here in the case is the level of harm. Okay, you have serious physical harm, and then you have physical harm. There's two different charges here. There's the felonious assault, which requires serious physical harm. That's a term of art and law, which the judge will instruct you on. And the lower offense of assault, which is just physical harm. So we have an offense here. You saw the video. Okay, nobody's getting hit with a baseball bat. Nobody's getting shot. Nobody's getting stabbed. As far as I could tell from that video, there was one punch to the face. That's it. There was a scuffle after that. I asked the corrections officer, was there a scuffle after that? He said, yeah, but it wasn't a punch like the first one. So you have to look at the evidence. What do we have here? We have someone who was assaulted 6 months earlier and had a broken nose. Was his nose still broken? We don't know. Could have been. Was it still broken that day? Very might have been. That's where we get into, was it serious physical harm or not, or was it just physical harm? During when talking to the corrections officer, he said, "I'll be fine." He said, "It made me mad more than anything else." He said he did his paperwork for an hour and a half, and then he drove himself to the hospital. Didn't take an ambulance. So I'm going to suggest to you that while he did have physical harm, he got punched. That hurts, for sure. He didn't have the serious physical harm caused by Mr. Schneider. Again, the judge is going to read these to you, but, the physical harm is a much lesser threshold than serious physical harm. And the prosecutor, Mr. View, listed all these things as incapacitation and all that. That didn't happen from the one punch to the face. It was just one punch where he said, and he told them on the video, "I'll be fine." He took some pain medication, did his paperwork, and that's fine. I'm not criticizing him. He did what he could do. That's what he could do. And then he went to the hospital by himself in his own car. Didn't take an ambulance, wasn't laying on the ground, wasn't crying. He's kind of a tough guy. The initial interaction was a little brusque. I'm sure he, after working in the jail for 31 years, he is a tough guy. Okay, and he's used to, maybe that's how he has to deal with people. But we're dealing with real evidence here, and that evidence is that video. You saw the video. There was a limited interaction about some styrofoam cups. I asked, are the styrofoam cups illegal? No. Did he have rocks? No, he had some pebbles. There was some kind of shaving thing that he said he was allowed to have. And then there was that punch to the face. And again, the state doesn't have to go why there was a punch in the face. They don't have to prove motive or anything like that. If they proved anything at all, it's count 2, which is that physical harm, assault on a corrections officer. That's the language of the account. They did not prove serious physical harm. We just don't know what happened from this punch. He was punched earlier. He admitted he had the broken nose. He admitted that before this incident, he was already using a CPAP machine because he couldn't breathe. And then 3 weeks later, he's making a workman's comp claim and saying his ribs were damaged. We don't know if that had anything to do with this. So I ask you to find not guilties, or if you're going to find any guilty at all, it would be on count 2. Thank you.
Mr. View?
Members of the jury, there is a reason why the judge instructs you that the things that Mr. McKenna and I say are not evidence, because they are arguments to you. You should rely on your recollections of what the evidence is. Evidence is the testimony of witnesses who take the stand. Evidence is photographs, documents, videos, not the things we say. Here's what I'll tell you, because I want you to remember this. Mr. McKenna asked Officer Hopper about the CPAP machine. And I want you to remember that, because Mr. McKenna said, oh, so you already had problems with breathing? And what did he say? No, I had problems with sleeping. The breathing happened after he smashed my nose. So that's why you need to talk to each other. You need to look at your notes, right? Remember, because the state makes accusations, right? It is my job to prove to you the things that have been alleged, the things that Mr. Snyder is accused of. That's my job. The person who is accused of the crime has the right to a trial. They can say, you accused me, you prove it. That's what we did today, right? You put on the witnesses, we put on the evidence so that you know what happened. Is there any reasonable argument to be made that this punch, even if it's only one punch, first of all, watch the videos, you can see him keep swinging on him, right? That somehow Officer Hopper already had a broken nose 6 months later. Well, we know it took him 3 months to heal from this one. We know he was ready to return to work. We know his nose wasn't out of his, joint across his face. Watch the video, watch the body camera. You can see the medical personnel from the prison saying, oh yeah, you can see that. You don't think they would have noticed if his nose was bleeding and out of joint before the defendant punched him in the face? And I don't have to prove to you that he hit him more than once. If he assaulted him, one punch, and that one punch resulted in a serious physical harm, that's a felonious assault. It takes one punch to break somebody's jaw. It takes one punch to knock somebody unconscious and they fall and hit their head on a brick and get a brain injury. It takes one punch to break someone's nose. That's a natural, foreseeable consequence. You're not going to hear the judge say, I have to prove to you that he hit him more than once. Only that the one punch that connected is the one that broke his nose, that caused these injuries that required this level of treatment. Remember, I told you during jury selection, I'm okay with proving to you the things that I am required to prove, but I don't want you to ask me to prove things I don't have to. The judge is not going to instruct you that I have to prove he was shot, that he was stabbed, that there was a weapon involved, right? Why would Mr. McKenna make those arguments to you? He wants you to think that this is not a serious physical harm, but the judge isn't going to tell you anything like that. The judge is going to tell you, look at what the evidence shows of what this injury is. It is a temporary, substantial incapacity. It is a temporary, serious disfigurement. It is acute pain that causes substantial suffering, and it is any degree of pain that is prolonged in duration. That's what Mr. Snyder did. That's the evidence that you heard. The judge is going to tell you not to speculate about things, not to guess about things that you didn't receive evidence on. There was no evidence that said, oh, he never really had, his nose was already broken. Mr. McKenna is inviting you to speculate about the evidence you did not hear. Mr. McKenna had the opportunity to ask Mr. Hopper, was your nose already broken? And he didn't. So you heard no evidence about that, and guessing about it is something you're not supposed to do. Members of the jury rely on your collective memory, rely on your notes, rely on what you know the evidence is. Those videos are not very long. If you retire to the jury room, you can watch them all, probably in under half an hour. Look through the medical records. They're all right there, but they're going to show you as a fractured nasal bone, 3 lacerations that required stitches and glue, and prescription pain medication. They're going to show you the evidence is that Jason Snyder committed a felonious assault and that Jason Snyder assaulted a corrections officer. Those are the crimes he was accused of. Those are the crimes that are proven. And those are the crimes you're going to find him guilty of. Thank you.
So, ladies and gentlemen, in the 20 or so years that I've been doing this, it's been my experience that different people absorb information in different ways. And right now, Ms. Kuroko is going to distribute to you a written copy of the jury instructions that I am about to read you. If you're one of those people that absorb information by reading and listening, following along, then you're going to have a printed copy of my materials. Sometimes I ad lib. I try to tell you when I leave the materials and when I get back so that you can follow along. If you're not that person and you just want to listen to what I have to say and not follow along, you can just place the instructions face down on your lap and you don't have to read through them. You can circle stuff and make notes if you would like, but the one thing that you can't do is sort of skip ahead and look at what's coming. And also, you will be taking this copy with you back into the jury room, so you will have your own individual copy. So we'll start here. Members of the jury, you have heard the evidence, the arguments of counsel. It is my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts. The court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law, nor to apply your own idea of what you think the law is or ought to be. The case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. You are not to consider the fact that it was filed for any purpose. The defendant has entered a plea of not guilty, which means you are not to assume that any of the facts alleged in the indictment are true. A plea of not guilty is a denial of the charge and puts at issue all the essential elements charged in the indictment. The defendant is presumed to be innocent until guilt is established beyond reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged. Now, what is reasonable doubt? Reasonable doubt is present when, after having carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's affairs. Evidence is all the testimony received from the witnesses and the exhibits that were admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all the elements beyond a reasonable doubt. Direct evidence is testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes the exhibits that were admitted during the trial. Circumstantial evidence, on the other hand, is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically flow according to the common experience of people. I'm going to depart from my script to give you an example. Let's say it's your job as jurors to determine whether or not it had rained outside. If we brought a witness in here and said, I saw that it was raining, that is direct evidence that it was raining. I show you a video, you see the rain coming down, again, direct evidence that it's raining. But if we brought a witness in that said, you know, when I came into the building, it was dry out. I heard a little pitter patter on the roof. When I went out, there was water on the ground and on the cars. That is indirect evidence, circumstantial evidence from which you could consider that it had rained. Returning here to infer or to make an inference is to reach a reasonable conclusion of fact that you may but are not required to make from other facts you find have been established by direct evidence. You may infer a fact or reach a conclusion only from other facts that you find have been proved by direct evidence. Whether an inference is made or not rests entirely with you. Direct and circumstantial evidence are both of equal probative value. The evidence does not include the indictment, the statements of the attorneys. The opening statements and closing arguments are designed to assist you. They are not evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to a question or what the answer to that question might have been, because these are questions of law that rest solely with the court. Likewise, you must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. These statements must be treated as though you never heard them. You are the judges of facts, the credibility of the witnesses, and the weight to be given to the testimony. In order to do this, in order to weigh evidence, you must consider the believability of the witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests may include the appearance of each witness on the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use the criteria that you believe to be the most appropriate and assign to each witness's testimony such weight as you think proper. You are not required to believe a witness simply because they were placed under oath. There can be a natural tendency to assign less credibility to a person because they do not look like you, talk like you, or worship at the same sort of place that you do, or perhaps more credibility if they are of the same race or gender as you. We talked about this in jury selection this morning. We call this implicit bias. Make sure when deciding any of the issues in the case, including credibility, that you're aware that there may be unconsciously on your part a thought process, and you should check yourself to make sure that your decisions are not based on race, religion, gender, disability, or sexual preference. Again, you're not required to believe the witness of any testimony of any witness simply because they were placed under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered by you for any purpose. Evidence was received that the defendant may have been incarcerated for an offense that is completely unrelated to these charges. That evidence was received only for a limited purpose. It was not received, and you may not consider it, to prove his character in order to show that he acted in conformity with that character. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects in the same condition or whether or not they accurately depict what they purport to be. You will determine what weight, if any, the exhibit should receive in light of all the evidence. It may be that not all the exhibits that were referenced during the trial were admitted into evidence. You are not to draw any inference by the fact that some of this evidence may not be admitted. You will have with you in the jury room the recorded exhibits and a computer without internet access with which to play these recordings. You shall consider whether the recording is a true record of what transpired at the time it was taken. If you find that it is, you will determine what weight, if any, the recording should receive in light of all the evidence. If you are unable to play the file on the computer and wish to view it, please contact Ms. Kuroko, who will help you with any of the technical aspects. The defendant is charged in count 1 with felonious assault. Before you can find the defendant guilty, you must find, beyond a reasonable doubt, that on or about December 23rd, 2024, and in Warren County, Ohio, the defendant knowingly caused serious physical harm to Donald Hopper. A person acts knowingly, regardless of purpose, when he is aware that the person's conduct will probably be of a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability the defendant knowingly caused serious physical harm to Mr. Hopper. Cause is an essential element of the, hold on, I don't know how to turn this off without answering. Sorry about that. All right. Cause is an essential element of the offense. Cause is an act which in a natural and continuous sequence directly produces the serious physical harm and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable results that follow in the ordinary course of events from that act. The state of Ohio need not prove the defendant intended to cause the specific harm that it resulted, but it must be established beyond a reasonable doubt that the harm that resulted was a natural and foreseeable result of his actions. Proof of motive is not required. As to the issue of whether the defendant acted knowingly. Serious physical harm means any of the following. 1, any physical harm that carries with it substantial risk of death. 2, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. 3, any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. Or 4, any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. The defendant is charged in count 2 with assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 23rd, 2024, and in Warren County, Ohio, the defendant knowingly caused, that's physical harm. Counsel, we agree that it's the count 2 is physical harm only, right?
That's correct.
Correct.
So everybody scratch out serious physical harm. I apologize for that error. Serious physical harm is only applicable to count 1, not to count 2. So
Yeah, Judge Cedric Simpson, maybe. And having done the waiver this morning. I'll lose it there, apparently.
I was hoping no one noticed.
Alan's the one that pointed it out to me. Court does call the case People versus Nicholas and Bonasai.
Requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney on the agenda.
Permission to practice this screening.
Good afternoon, Assistant Public Defender Laura appearing on behalf of Mr. Bosniak. Sir, please state your name for the record.
Nicholas Michael Bosonic III.
Masonic, yeah, it's like every time we see him, we mess it up. And I'm before I called it, I'm staring at him going, I know it's not how we got it right. But anyway.
It's like Masonic. Masonic. Anyways, okay.
Like vinegar. No, I'm kidding.
That's
No, I'm kidding.
Need to write in the file.
All right, what are we doing?
Your Honor, we are requesting an adjournment of the pre-trial for continued discussions with the people. Obviously, this case is quite old, and Mr. Bosonic lives in New Zealand. So there are some things that we want to work out.
Like how we're gonna get him back here? Or how we're gonna go over there to handle the case?
I'd love to go. That would be great.
Go over there. All Okay, how much time are you guys gonna?
I think that's the standard 2 weeks to be sufficient.
I think it will. All right. Adjourn the pretrial in this matter to, what is that, to
June 30th at 1 p.m.
June 30th, 2025, 1 p.m. All right. Bond will continue. All right. Thank you, sir.
Thank you.
What time is it there?
5 a.m., 5:19.
Ow. Ow. Sorry.
You're fine. Not a problem at all.
All right. You take care of yourself.
Thank you. You do the same, sir.
Court does call the case of the people versus Eric Buckner.
Alexander, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Buckner. Your Honor, I'm not sure if Mr. Buckner is present.
Oh, I have an Eric Buckner.
Yes.
Oh, there he is. You'll have to unmute, sir. All right, state your name.
Yes, can you hear me? Eric Buckner?
Yes, we can hear you.
Sorry.
All right, I just need you to state your name. You're breaking up a little bit there.
Eric Buckner?
Bit of delay, but.
Your Honor, I spoke with Ms. Zenda prior to the docket. Do you want to approach?
Who would approach first, Your Honor?
You may.
Yes, I'm here.
Okay, we're back on the record on this case.
No.
I'm going to adjourn your case to June 30th, 2025 at 1 p.m. That will be an in-person hearing.
Okay.
All right, so you have to be here.
Yes, sir.
Okay. All right. Thank you. Con continue. Court does call the case People versus Jajamoa Byers.
Oh, Claire Lowe on behalf.
Good
Need to
afternoon.
wake you. All right. Well,
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Byers. Ms. Byers, please state your name for the record.
Deja Moye Byers.
okay.
Your Honor, we are requesting that this case be set for final settlement, please.
Jury final settlement conference will be set for
August 8th, 2025 at 9 a.m.
August 8th, 2025, 9 a.m. Jury selection, if necessary, will be August 11th, 2025, 8:30. Both of those proceedings are in person. Bond continued. Thank you.
Thank you. You're all
Thank
set,
you.
Ms. Byers.
Thank you.
Thank you. Court calls the case, People versus Marquand, is it Grace?
On behalf of the people.
Oh, there he is.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Gracie, who is approaching. State your name for the record, please. Ms.
Marquand
Gracie.
Gracie. Gracie, all right.
Your Honor, we are also asking to set this case for final settlement, please.
Jury final settlement conference will be August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. All right, bond will continue.
Thank you.
Thank you. Court does call the case, People versus Douglas Lee.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lee.
There's an individual who signed on Samsung. Could you unmute and state your name, please?
Can you hear me now?
Yes, what's your name?
Douglas Lee.
Okay, that's Mr. Lee. All right, I need a camera on, sir.
Yes, sir. I'm still trying to figure this one out. All right. Okay, I hope this is it.
There should be a little camera with a line through it. You want to click that,
I'm clicking it.
maybe.
I'm definitely clicking it. Oh no. Please work with me. I'm sorry, I'm really trying to work this. Yeah. Oh. Uh-oh. That's switching cameras. I don't know how to work this. Oh my goodness.
Send me a request, sir.
Oh goodness, I don't know how to work it. They all heard my video, yes.
Oh, there you are. We've got you now.
Thank you very much for your patience. I'm sorry.
Oh, I wasn't patient. We were gonna come find you. No, I'm kidding.
Oh.
All right. What are we doing? State your name, sir.
Douglas Tyrone Lee.
Thank you. All right. What are we doing?
Your Honor, we are requesting an adjournment of the pretrial. Ms. Pate would like to review all the media with Mr. Lee.
I'll adjourn this matter then to June 30th, 2025, 1 p.m. All right. Thank you. Now he knows how to work the camera, so we won't have the same problem.
Thank you, Your Honor.
You have a good day, sir. Thank you.
You too. Oh, one more thing. Happy belated Father's Day.
What you say?
Happy Father's Day.
Oh, and to you, sir.
Yes, sir.
Court calls the case, People versus, is it Jaquil Lloyd? I got that right.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lloyd. Mr. Lloyd, please say your name for the record.
Yes, Jaquil Elijah Lloyd.
All right, thank you.
Your Honor, two things. First, we are asking to address his bond conditions. There was a bond condition that was set at arraignment for drug testing. Ms. Zenda and I spoke this afternoon and reviewed the police report together. And there were no allegations in this case that Mr. Lloyd consumed drugs or alcohol or that led to the charges. Ms. Zenda also reviewed his criminal history, and we didn't see any indication of drug or alcohol related prior cases. So I'm asking for the drug testing condition to be lifted. And I don't want to speak with Ms. Enda, but I believe she has no objection to that.
That's correct. No objection from people.
All right. Then I don't have a problem. And counsel, you may want to just prepare an order, because currently what I have is that he's on testing 2 times per month.
Correct. Yeah, that's what I have.
Sir, have you taken a test already?
Yes. I've been down there. Yes. I'm all
Okay, but and you tested?
Yes, for the first test.
Did it come back clean?
Yes, when I went down there, yes.
Okay. Then if you prepare an order, as long as his test came back clean, then I don't have a problem removing that condition.
Okay. Thank you for the consideration, Your Honor.
Oh, is there a problem?
Can we approach briefly?
You know, Ally, I'm just gonna get Ally a chair up here.
Oh, no.
I don't know what happened.
Sir, we'll be right back with you.
Okay.
All right,
Hello?
we're back on the record on the case of the People versus Lloyd. Sir, I have an indication that you actually came back with marijuana in your system. Do you have a medical marijuana card?
No, not currently, not anymore, no.
Pardon?
I said no, not anymore, no.
Okay. So you can't be, hold on, you can't be using. So I'm not going to order that the drug testing stop at this point. We're going to get a couple of more tests, and the levels need to be going down.
Okay, can I say something or no? But it don't even, never mind. It don't even matter. We're not gonna care.
We'll call you, Mr. Lloyd, to explain
All right.
what's going on.
Yeah, talk to your attorney about it. All right, so when you want, just 2 weeks?
Please, he should test again then.
Yeah, he should be. So I'll adjourn this to June 30th, 2025 at 1 p.m. Okay, sir?
All right. I understand, Your Honor.
All right. All right. Thank you. Bond continued. Court does call the case, People versus Alexis Naveen.
It's my turn now, Your Honor. Good afternoon, Assistant Public Defender Lauren Perny. On behalf of Ms. Naveen, can we approach, please?
Sure. Old court. In this case, I will adjourn this matter to June, bless you, 30th, 2025, 1 p.m. Bond will continue. Thank you. Court does call the case People versus William Fridge.
Is Mr. Bridge present?
He is not.
Your Honor, that surprises me because Mr.
I know.
Bridge, this is Teresa Claire on behalf of probation, by the way. Mr. Bridge has been compliant with me otherwise, and has been reporting. The issue today is regarding his payments. He's not made any payments and has been arrears $250.
I'm going to, and I agree with you. I would, not only is he compliant, I find it unusual that Mr. Fridge is not appearing. So what I'm going to do is I'll indicate that defendant failed to appear at this proceeding, but I'll adjourn this out to June 30th.
Thank you, Your Honor.
2025, 1 p.m. Court calls the case People versus Jason Orr.
Ellie Zend on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Orr. Your Honor, I'm not sure if Mr. Orr is on Zoom. However, I did speak with him today. And Ms. Pilar, and she didn't he had to be here in person due to the new allegations. He indicated to me that he was working on the line today and could not get off at short notice. He was waived up until this morning, as the court knows. So that is why he's not present today.
Right, because we weren't aware of contact.
Right.
So Teresa Claire on behalf of probation, Your Honor, given that Mr. Orr is not present and there was a police report that was received over the weekend regarding a violation of the no contact order, probation is requesting that the court issue a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Does call the case People versus Alfredo Gonzalez Lopez.
On behalf of the people. Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Gonzalez Lopez, whose appearance has been waived.
And Teresa Claire on behalf of probation, Your Honor, Mr. Gonzalez Lopez is scheduled before the court for a review